I pledge allegiance to the flag of the United States of America, to the republic which stands, indivisible, justice for all. Thank you. Please be seated. Good morning, everyone. I want to welcome you to the June 21st, 2021 Land Use Hearing Officer hearing. My name is Susan Finch, and I'll be presiding as the hearing officer over all of today's cases. Let me start by introducing Mr. Tom Hisney to my left. He's with the county's Development Services Department. He'll go over any changes we have on today's agenda. Mr. Hisney.
Good morning, Madam Hearing Master. My name is Tom Hisney with Development Services. I'll be introducing today's cases. To my left is Carmen Mason. She works with Development Services also. She's in operations support. We will be joined virtually by a number of different planners on the various cases. Also in attendance today virtually are Mary Dorman and Cameron Clark of the County Attorney's Office. We have no changes to the agenda today, so I'm going to read into the record the published withdrawals and continuances. Item A1, variance 21-0202, the applicant Eric Jones. This application has been withdrawn by the applicant. Item A2, variance application 21-0338, the applicant is Keith Bolton. This application is being continued by the applicant to the July 26, 2021 Land Use Hearing Officer meeting. Item A3, special use application 21-0375. The applicant is Trademark Metals Recycling. This application is being continued by staff to the July 26, 2021 Land Use Hearing Officer meeting. Item A4, variance application 21-0532. Applicant is Nick Bracken. This application is out of order to be heard and is being continued to the July 26, 2021 Land Use Hearing Officer meeting. Item A5, variance application 21-0573. Applicant is Brandon R.E. Holdings. This application is out of order to be heard and is being continued to the July 26, 2021 Land Use Hearing Officer meeting. Item A6, special use application 21-0606. The applicant is Dune Florida Land 1 Sub LLC and South Shore Bay Club LLC. This application is being continued by staff to the July 26, 2021 Land Use Hearing Officer meeting. Item A7, variance application 21-0641. The applicant is Jennifer Snow. This application has been withdrawn by the applicant. Item A8, variance application 21-0652. Applicant is Laura Berta. This application is out of order to be heard and is being continued to the July 26, 2021 Land Use Hearing Officer meeting. Item A9, special use application 21-0711. The applicant is Northdale Tampa. This application is being continued by staff to the July 26, 2021 Land Use Hearing Officer meeting. Item A10, variance application 21-0713. William and Paula Hernandez. This application is being continued by staff to the July 26, 2021 Land Use Hearing Officer meeting. Item A11, variance application 21-0714. Applicant is Michelle Anderson. This application is out of order to be heard and is being continued to the July 26, 2021 Land Use Hearing Officer meeting. And finally, item A12, special use application 21-0733. The applicant is John Montgomery. This application has been withdrawn by the applicant.
All right. Thank you so much, Mr. Hisney. I appreciate it. Let me start by going over our procedures for today's hearing. I'll conduct the variance and special use hearings today as the hearing officer and render a decision within 15 business days following today's hearing. Our hearing today is informal. I'll ask questions related to direct testimony presented today. I'll call and question witnesses as I deem appropriate, and will decide all questions on procedure. Irrelevant, immaterial, or unduly repetitious evidence will be excluded. Any part of evidence may be received in written form, and all testimony must be under oath. Hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but shall not be sufficient in and of itself to support a finding by me unless it would be admissible over objections in a civil action. Our order of presentation today is as follows. We have the majority of our cases this morning are variance cases, and then we have special use cases at the end of the agenda. The process is identical except for two things. One is the Development Service Center and both department in both instances present a brief introduction of each agenda item. But for variances, then also the staff goes first and presents their finding on the variance application. For special uses, the applicant goes first. So that's the difference. But otherwise, the rest of the procedure is as follows. We have the applicant has 15 minutes to present their case in total. Then we'll go to proponents. Proponents, anyone who would like to speak in support of an application, total time 15 minutes. Then we'll then go to opponents, anyone who would like to speak against an application, total time 15 minutes. We'll go back to county staff who has 5 minutes to make any comments or revisions based on today's testimony. And then finally, we go back to the applicant who has 5 minutes for rebuttal. If you are going to speak, either here in the room or we have people signed up to speak virtually, if you could start by giving us your name and address for the record. If you're here in the room, there's a microphone up at the podium. Just make sure you pull it to your mouth so we can hear you clearly. We are recording this hearing and we want to make sure we've got an accurate representation. I'm not sure we have this issue, but if there are a number of people that want to speak in either support or in opposition to any case today, we will ask you, or I'll ask you to raise your hand. I'll count them and I will divide that 15 minutes as equally as we can to try to keep us on schedule and give everybody an opportunity to talk. When you are done, if you're in the room and you speak, when you are done with your presentation or comments, if you could see Michael, he's to my right, he's with the clerk's office. And if you could also sign in with your name, address, and the case number that you are speaking to. Let me go to the county attorney now, who will explain the appeal rights for decisions made by the land use hearing officer.
Good morning. This is Mary Dorman from the county attorney's office. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed the case, the record of that case is also closed and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the appeals board that is outside the record created at today's hearing could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the appeals board.
Thank you so much. I appreciate that. As I mentioned, all testimony must be under oath. So if you are in the room or testifying virtually, if you plan to speak today, if you could please stand and raise your right hand and I'll swear you in. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I
Thank you. Please be seated. All right, Mr. Hisney, we're ready for the first case.
All right, we have no vested rights cases nor any fee waiver requests, which then takes us to section D of our agenda, which is remands. Item D1 is variance application 20-0951. The applicant is Stephen and Marcella Price. The request is a variance to allow a third lot on septic tank in the urban service area. The subject variance was heard by the land use hearing officer on August 17, 2020. The applicant requested a variance to allow a proposed 3-lot subdivision in the urban service area to be served by private septic tank. The land use hearing officer denied the request on September 8th, 2020. The applicant appealed the decision to the Land Use Appeals Board. The LUAB heard the appeal, which was APP 20-1340 on December 4th, 2020. However, separate motions by the LUAB to uphold the LUHO decision or alternatively to remand the decision both failed to pass due to tie votes. Therefore, the matter was continued to the next LUAB meeting. The LUAB heard the appeal again on April 9th, 2020 and remanded the LUHO's decision for further consideration of variance review criteria numbers 1, 2, 4, and 6. As stated, this request is for a variance to allow the creation of 3 single-family lots to be served by septic tanks in the urban service area to accommodate the proposed subdivision of property zoned ASC1. The subject property is occupied by 2 single-family homes, each served by a septic tank. The applicant proposes to divide the property in 3 lots, 2 of which will be occupied one of the existing homes. According to utilities review staff, connection to public wastewater service is not feasible as the nearest point of connection is 6,500 feet from the subject property. The 2 existing homes on the subject property share a private well. Staff has advised the applicant that homes cannot share the well once the property is subdivided. Public water service is available adjacent to property, and connection to public water service will be required for the home that will no longer be served by the well and for the new home that would be constructed on the 3rd lot.
All right, thank you so much. Now we're ready for the applicant. Good morning.
Good morning.
Good morning.
Ann Pollock, 433 Central Avenue, St. Petersburg. I represent the applicants, Stephen and Marcella Price. Thank you. We're back here again, but hoping to really show you how we do have a hardship and that this is a reasonable and fair and appropriate variance to request. They own the subject property, a 4-acre parcel in a unique portion of the county that's in the urban service area, but generally surrounded by the Alafaya River on the north, east, and west, mostly zoned ASC1 with Res 4 land use, and primarily developed with 1 to 2 acre lots and without any sewer service closer than 1.25 miles. And here on this aerial, you can see where the property is and how it really is surrounded by the river. And what that river does is it makes it this unique kind of enclave. And this is zoning maps from close in and further out. And you can continually see where the property is and how it's surrounded by a mostly rural area and not much around it. The property was passed down to Mrs. Price in 2010 from her mother, who had owned it since 1971, and in 72 built 2 homes on the parcel. Presumably they are legal nonconformities built before the current regulations went into effect in 1989. Both the zoning and the land use designation allow 1-acre lots, and they would like to complete the development of this property as it was envisioned almost 50 years ago to have a 3rd parcel, 3rd lot, 3rd home on the property. This is a conceptual proposal of what they're thinking to do. It would meet all subdivision and development requirements. It would resolve the nonconformity, and it would allow them to retire as they've planned. However, to apply for the subdivision, they first need the approval to allow this third septic. We've submitted a detailed variance review criteria narrative into the record that we would ask that you review as well, but I'm going to go through some of this criteria today. We feel that the property has some very unique characteristics that have created hardships, not suffered in common with others. The subject property is a single parcel with 2 homes on it that were built back when you were allowed to build 2 homes on 1 lot. This isn't common in the urban service area or this neighborhood. No properties in the area are so uniquely situated like the Prices. And I actually looked at some of the properties around, and there's a lot of barns, buildings like garages, accessory buildings, but there really isn't the situation where they have 2 homes. The Prices homes are spread out, as you can see on the site plan, with plenty of room for a third. They all face north, aligned to front the proposed easement that would run along the north end of the property. And at about 1,900 and 1,600 gross square feet, they are considerably larger than accessory buildings. But unlike other large properties in the area, which also might want to subdivide, subdivision of this property additionally requires taking care of that nonconformity. If the property had been configuration and the layout, as you can see, 1 home is behind the other and only 1 really fronts on Potts Road. So any split would require this easement, which requires a subdivision. And to have a subdivision, you need to meet the wastewater requirements, which requires this variance. Even if they could split it to have 2 frontages along Potts Road, they would still have to resolve that nonconformity. The other hardship is generally the location of the property. It's been in the same family for 50 years, and the 2 homes have been operating successfully, each with its own septic system. But even though now it's in the urban service area and has to follow those rules, the relatively rural enclave south of the river has no sewer anywhere near to connect to. This is a map of the wastewater treatment plants, and you can see in orange the area that we're talking about, that little yellow enclave with no wastewater there. And there's a little dot right in the middle where their property is.
Can you point to that on that map? I see. Okay, thank you.
So that's another map that shows the property and the little bit of wastewater that there is far away. These are kind of old maps, so I checked the county's capital improvements program, and in fact, there are no active cases. And the cases that have been closed out are stormwater or transportation. There's basically been no effort by the county to make any wastewater improvements in this area. So the county staff, as Tom mentioned, have determined that the closest wastewater connection is more than 1.25 miles away, 6,730 feet. Connection is infeasible. And so we really have this unique location and feel that the Prices should not be punished for that. Instead, the literal requirements of the Land Development Code are depriving them of rights commonly enjoyed. The split would be consistent with the zoning and the development pattern of the area. It would meet all code requirements except for wastewater. And yet, because the property was never split to resolve this nonconformity, they're unable to move forward. They know they have to comply with subdivision, with the easement rules, with the nonconformity rules, and they're all set on that. But the only thing left that otherwise, if the property had been split before, that the county wouldn't even bat an eye at, they're now left with this sewer issue. The literal requirements of the code on this sewer service shuts it all down. Fortunately, this variance is very much in harmony with the Land Development Code and the comp plan. It is in harmony with the land development requirement to encourage nonconformities to be voluntarily removed or otherwise brought into compliance. It's in conformance with the Land Development Code's requirements for property access, as it would allow the property owners to split the property while ensuring proper and adequate access. It's generally in harmony with the Land Development Code on sewer service, which allows this variance for a third septic when the connection to wastewater is determined to be infeasible, like the county staff have determined here today. Moreover, it's consistent with the comp plan. The relevant policy is 1.5. It generally discourages the use of septic in the urban service area. However, it does allow it under two circumstances. First is when there's a hardship, which we feel we've demonstrated. And second is when reasonable use of the property would be unavailable. The definition of unavailable for wastewater, it comes from the Florida statutes, 381.0065. It's when the services are in a public easement or right-of-way that abuts the property. Obviously, this is not the case. Wastewater is about a mile away. But with the requirement to have sewer and no sewer available or coming anytime soon, full reasonable use of the property is unavailable. And so this request is therefore consistent with 1.5, especially since strict adherence is not possible. It's also consistent with policy 1.2, which mandates that parcels and categories allowing 4 units per acre, like Res 4, be developed at a density of at least 75% of the allowable density of the land use category. So here we've got a 4-acre property. We're proposing 3 units, and that results in at least 75% of the allowable density on the land, which is consistent with that policy. So even though we can't meet the sewer requirement, we still are meeting the overall goal of bringing in more density into this area, even if it's only 1 unit and not a full subdivision. Finally, we think it would be against the general intent of the comp plan, the land development code, and a substantial injustice to value suburban level densities, but to deny the rights to use the entitlements, allowing them to have an extra unit here, given the unique circumstances of this property that are uncommon to others in the area. It's just not reasonable to limit them to 2 lots. It's inconsistent with the urban service area and the comp plan, which encourage denser development. And it's also inconsistent with the general development plan of the area. This property is in this unique location separated from the rest of the urban service area by the river. And as a result, it is kind of more secluded. It's kept its rural nature. 1 to 2 acre lots are the norm. And although the county may desire more suburban type development, they really are a long time from getting to that point. And in the meantime, the prices are up against a lot of hardships that we've mentioned. They're trying to develop as densely as possible and has been planned for about 50 years, cure the nonconformity, and be in conformance with the plan. But the land development code is limiting them by the septic requirement. So we feel that approving this would be in accordance with the public benefits secured by the zoning and the applicable regulations, which they can meet all the others, and would not allow these hardships to cause further unreasonable or unfair suffering. So we would respectfully request your support. We've got 6 letters to submit into the record from neighbors that support. We also have Mr. and Mrs. Price would like to say a few words today.
Absolutely. You've got about 4 minutes left on your time. Good morning.
Good morning. I'm Marcella Price. My husband, Stephen, and I are the property owners at 7207 Potts Road, Hillsborough County, Florida. We inherited this property upon my mother's death. She and my father purchased the parcel 50 years ago and developed only half of the 4 acres by building 2 homes with 2 septic tanks. They left half of the property completely undeveloped, and it remains that way today. We wish to develop the vacant portion with the addition of 1 single-family home with a septic, while simultaneously bringing the property into conformity with the county's plan of 1 home with septic per parcel. However, a lot of the county's regulations have changed in 50 years, and frankly, some of them are overly limiting to the point that they actually contradict the county's own stated goals. This is the case with us. We are in an urban development area, an area that 1, requires new construction to use county water and sewage, and 2, seeks to encourage growth. However, there is no county sewage available to us, so the only way the county can develop in our neighborhood is through using septic tanks for wastewater. This requires the county to issue a variance. Denying a septic variance in this case denies the county of growth, which is a goal. It also denies the county of additional tax revenue, which would be derived from this growth. Approval of the septic variance would be a win for us, the property owners, and the neighborhood. But it is also a win for the county in adding growth and tax revenue as intended by the urban development plan. So thank you. I look forward to approval of this request.
Thank you so much for your testimony. If you could please sign in with the clerk's office.
I think Mr. Price is going to wait for rebuttal to speak.
Absolutely.
He would like to read in the letters into the record. Is that something we can do as part of the support time?
Yes, I have 3 people signed up to speak
Wonderful.
virtually in support. Are those people the same?
I don't know.
All right,
but they
so I
might
have
be.
Mr. Lassinger, Rush, and Swint that are signed up virtually to speak.
I know Mr. Lassinger and Mr. Rush, we have letters from them.
Okay.
So I don't know the other.
All right, and Swint, he signed up to speak virtually as well. So
Okay,
if you
great.
want to read the other ones into the record, that's fine.
Sure. So from Janet Morehouse, 11603 Wynn Road in Riverview. I live in the same neighborhood as Stephen and Marcella. I knew Marcella's mother quite well, and it has always been their intention to split the property and build a third home. When her husband passed away, Marcella's father, she lost interest in the endeavor and decided to leave the task to Stephen and Marcella. The septic tank variance they are requesting will allow them to complete their father's dream of fully building out the property. The construction of a house on the land that is currently vacant would be a good thing for the neighborhood and be consistent with the current homes found in that area. The granting of the variance will allow an increase in density without negatively affecting anyone and permit the family to finally realize the full potential of the land. From Desi Green, who lives at 11425 Wynn Road in Riverview. My house is located adjacent to the Price's 4-acre lot. I would like to state my support for variance 20-0951. They're asking to do nothing more than continue developing the neighborhood as most of us have already done. The addition of a new home on the undeveloped portion of their property will obviously help increase property values throughout the neighborhood. Its construction will also help deter crime by reducing vacant land. I would ask that the Prices be granted this variance. Okay. Larry Wimble at 7005 Dusty Road in Riverview. I live one street over from Stephen and Marcella. They have been working on getting the property split for many years. We are excited to see that they may finally be able to obtain the variance to build the house they deserve. The addition of one more septic tank in a subdivision that is serviced 100% by septic tanks will in no way be detrimental to the neighborhood. The addition of a new house will assist in raising property values for everyone and minimize vacant land in the neighborhood. There's no reason why the Prices should not be granted this variance, as it is in keeping with the rest of the area. And I think the last one, other than who's speaking, is Dan Wimble, 7224 Potts Road. I live on Potts Road, 2 doors down from Stephen and Marcella. We understand they are trying to split their property, allowing them to build a new home for themselves. As a very close neighbor, we would be more likely to be affected than many others in the neighborhood. However, there is no negative to their request. It is obviously legal for them to build this house, but only if granted a variance for one single septic tank. Since there is a variance process for this request, it's obviously legal, and therefore, since it does not create a negative impact, the variance should be granted.
Let me ask you one question before you go. The two homes that are there and then the desire to subdivide for a third lot. If they could connect to public sewer, they could meet for those 3 lots, they could meet all of the requirements of the land development code?
That's correct.
Okay.
Mhm.
Thank you very much. If you could please sign in. And do you plan to submit those documents?
Yes, I have them.
Perfect. Thank you so much. I really appreciate it. All right, we'll go to proponents, those who want to speak. I do, as I mentioned, I now have 4 people virtually that want to speak in support. Is there anyone in the room that would like to speak in support? Seeing no one? All right, let's go to our participants virtually. 4
Mr.
people
Rush?
will say a little less than, we have 15 minutes total. So if you could put 2.5 minutes each, and then we'll be lenient with that as we go along. Go ahead.
Mr. Rush?
Make sure everybody can hear me okay?
Yes, we can.
Okay. You'll see in the letter, I live directly behind Steve and Marcella. So
Mr. Rush, I'm sorry. Could you give us your name and address, please?
Chris Rush, and it's 11503 Rustic Pine Court.
Thank you so much. Go ahead.
And yes, ma'am. And like I said, I live directly behind them. They've done a nice job of showing you, and I'm in new construction too. They've done a great job of showing you kind of the parcel layout, and even the neighborhood. But if you look at the other ones, we understand in our neighborhood that we are a 1-for-1, 1 acre for one, one septic. But you have to understand where they're located at, that most of the homes surrounding them are around 2 acres or even bigger. So you've got plenty of, you've got plenty of room there, so to speak, including the property to the north of them is another 4 acres. And that's vacant. So that's what that's where it's not detrimental to the neighborhood at all. I knew Marcella's mother. I've lived in the neighborhood for 20 years. And I knew this has always been the dream. And I just, in the business, I just don't see how we deny this.
All right. Thank you, sir. I appreciate your testimony. Next, please.
And then we also have Chris Kierman on the line. Chris, I see you've called in. Can you please enable your video?
I don't have that capability.
We have a requirement that we have to be able to see you. If the county attorney could you please weigh in on that briefly? Either Ms. Dorman or Mr. Clark.
I don't have any way of broadcasting a video. I wasn't aware that I had to.
All right. Mr. Clark, are you available, or Ms. Dorman? With the county attorney's office?
Ms. Dorman?
Madam Hearing Officer?
Yes.
This is Ms. Dorman. Sorry, I was muted. It's my understanding that the person who wishes to speak needs to be visible in order to be able to speak at this proceeding.
All right. Thank you.
And
Thank you for that.
And Madam Hearing Officer, this is Mr. Clark. Just to reiterate that, and that requirement is contained in all the notices for the hearing. So the main reason is just to ensure that the parties of record are sworn, they're under oath, and so they have to be recognizable in case the decision is appealed.
All right. Thank you for that. I appreciate it. Let's go to the next person then.
Okay. Mr. Swin said that he was not available. And
All right.
then James Lassinger never logged into the meeting.
All right. Anybody else that would like to speak in support? Seeing no one. Ms. Pollock, those persons that were unable to participate, you submitted their letters into the record? Yes. Okay. All right. Then just for their information, know that your comments have been submitted and will be reviewed. All right. We'll now go to anyone that would like to speak in opposition. Anyone opposed to this application? All right. Seeing no one virtually. All right. County staff, do you have any additional comments?
No, ma'am.
All right. Let me just ask you a quick question. I understand that this application was filed prior to the change in the land development code.
That is correct.
And can you explain what that change was?
Sure. Late last year, the land development code was amended effective January 1st. So prior to January 1st, properties located in the urban service area, if connection to public water or wastewater service was not feasible, then by county technical standards, then they were permitted to subdivide into 2 lots by right, and then with a variance into 3 lots. However, effective January 1st, all subdivisions of property in the urban service area must connect to public water and wastewater, including 2-lot subdivision.
And what was the purpose of that change?
That was, I wasn't really involved in the amendment. It was directed by the Board of County Commissioners.
To have all lots in the urban area or service area?
Have all subdivision, all development in that above 1 ERC. So if you have an existing lot that's in the urban service area and it's not feasible to connect, a vacant parcel, then you can use well and or septic if it's not feasible to connect. But all subdivisions of property and non-residential development above 2 ERCs must now connect.
Okay, thank you so much. And understanding that I am well aware that this was filed under the prior version of the code. Mr. Clark of the County Attorney's Office, if I could just ask you a quick question?
Go ahead.
Thank you. Can you go over the case law that we've previously discussed in other, when this issue comes up of a third lot in the urban service area on septic, the case law regarding feasibility in terms of cost to connection to public sewer?
Yes, very briefly, the standard of review for a second lot that staff undertakes is a different. The feasibility review is not the same as the hearing officer. The hearing officer is going to be looking at the 6 variance criteria, the same as any other variance. And in terms of cost, there is case law that states that economic hardship by itself is insufficient to justify a hardship to fund for a variance. So if it is in support of other hardships that are unique and singular to the property, that is something that could be considered, but an economic hardship by itself cannot justify a variance.
All right, thank you for that. I appreciate it. All right, those are the end of my questions. Ms. Pollock, you have 5 minutes.
Actually, Madam Hiernos, before we leave.
Hold on 1 second.
We do happen to have in the audience today, Brian Grady, who may be able to answer your question as to the intent of the change in the land development code that was regarding septic tanks.
All right, Mr. Grady, if you'd like to weigh in, you're more than welcome to.
Brian Grady, Hillsborough County Development Services. Could you repeat what your question?
My question was, I'm aware that this application was filed under a prior code requirement that allowed a parent parcel in the urban service area to divide into 2 lots using septic tank and then obtain a variance for a 3rd lot, if so granted. And I understand Mr. Hisney went over the change to the land development code that was made, and I was asking what was the purpose and intent of that change?
Generally, the purpose and intent of that change was to no longer allow subdivisions of property in the urban service area to be on well and septic. So that was the board's intent, was basically not to allow any further subdivision beyond existing lots unless they're on public water and public sewer. Water you can still make variance, but for septic is to be on public sewer.
All right, thank you so much for that clarification.
You're welcome.
Ms. Pollock, we'll go back to you. You have 5 minutes for rebuttal.
Thank you. And I just want to address those 2 things. One, I mean, I think you understand that what the change that has made is not relevant to this decision because we are under the previous code. And the reason why they did it is not relevant. But I will add that we won't be setting precedent. An approval here today certainly won't be setting precedent because we're at the end of the line here for what can be done. With regard to the cost infeasibility, yes, it is cost infeasible. But we feel we have significantly described the other hardships that relate to this property that are unrelated to the cost that it would take to connect sewer here. And so we feel that we have met those requirements. I'm going to let Mr. Price speak generally, and we appreciate your support.
All right, thank you so much. Good morning.
Good morning. My name's Stephen Price, 7205 Potts Road. My wife and I are joint owners of the property. I have a prepared statement, but I'd like to speak about the cost feasibility first while that thought's in my mind. In my mind, there's a disconnect in what was stated. Cost feasibility is not a hardship. Now, is that the cost of the county to bring the wastewater to my curb so I can connect as it should be? Or is it the cost of me going from my house to the curb? I have no problem with going from my house to the curb if it was there. There is no cost hardship on my behalf. The cost hardship is the county's because they refuse to bring wastewater to me. Okay? Generally speaking, is it legal for me to have a multi-family dwelling on my property? No. In layman's terms, it's illegal to do so. How do we know this cannot be done? There's not even a variance that could be obtained to allow that type of structure in the area zoned for single-family dwellings. Are there septic tanks allowed on my property? Yes. We know this because there's at least a variance process to get the permission to use a septic tank. Any property owner should be allowed to do whatever they wish on their own property, providing it is not illegal, nor has a negative impact on their neighbors or their neighborhood. There are approximately 150 plus single-family dwellings in our immediate neighborhood that are serviced by septic systems. The addition of one more septic tank will in no way be negative to the neighborhood. The problem we are facing is that due to the shape of our property, we are forced to use the word subdivision instead of the simpler reparceling term. Subdivision conjures up mental images of hundreds of houses placed on postage stamp sized lots, all being serviced by septic tanks. I understand that is the practice the county wants to eliminate. The variance process, however, was written specifically for instances such as ours, where we need one septic tank to meet the county's own desires of a 75% population density. Also, as Ann just stated, since we filed our variance, the rules have changed with regards to septic systems. We are the last that will be approved under the old rules, and therefore this variance approval will in no way set any precedents for future decisions. We are not asking to do anything that has not already been done by every lot with a single-family dwelling, the right to install a septic system and build a home. That's all. Thank you.
Thank you, sir. If you could please sign in with the clerk's office. Ms. Pollock, you have another minute if you'd like to take it. You don't have to.
Just one more respectful request to approve.
All right. Thank you so much
for
I
your
appreciate
help.
Time and testimony. And with that, we'll close variance 20-0951 and go to the next case.
Yeah, that concludes section D of the agenda, which takes us then to section E, site development variance request. First item is E1, application 21-0605. The applicant is David and Amanda Alba. They're requesting a variance to encroach into the wetland setback. Staff findings will be presented by Ryan Joyce.
All right. Mr. Joyce.
Mr. Joyce, you're muted.
Okay. Sorry, can you hear me?
Yes, we can.
Okay. This is Ryan Joyce, Hillsborough County Natural Resources. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on May 19th, 2021, is to allow for construction of a portion of a swimming pool and deck within a 30-foot wetland conservation area setback. For LDC section 4.01.07.B.4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of a portion of a swimming pool and deck within the 30-foot wetland conservation area setback. The applicant requests a 13-foot 5 3/4 reduction of the setback to allow for a setback of 16 feet 6 1/4 inches. And there were no findings with that one.
All right. Thank you for your testimony. Is the applicant here? Come forward, please. Start by giving us your name and address, please, sir.
My name is David Albaugh. I live at 11920.
Excuse me, sir. Excuse me. Would you please put your mask up, including over your nose? Thank you.
Okay.
All right. If you could just give us a brief description of the request.
When we bought the property, we were not informed due to the seller not disclosing that the wetlands were as extensive as they were. We understand we had a small pond in the back, but we thought the rest of the land would be usable, which we found out otherwise. And we were going to put the pool in the back of the house, but that encroached too much into the actual wetlands. So we then looked at it and we moved it at the area behind what would be considered my the master bedroom. This is this drawing right here I did. The blue part is the actual pool. The yellow line surrounding it is the area that we would be going.
Sorry, you just have to speak into the microphone.
Oh, okay. If you look at the yellow line, that's the actual outline of the extent of the construction. On there, it's behind the house. The green part bit is the part of the wetlands that would be the second half of the 30-foot encroachment area is the part we're going. We are 16 feet, 6 1/4 inches away from the actual wetlands on that part. This here is the optimal place to put a swimming pool. On here, I do have okay from the HOA. I also checked that virtually every neighbor I have has a swimming pool. And this is what we, best situation we worked out for what we wanted on this here. The variance does stipulate that you're allowed, funny enough, they put actually swimming pool in the variance application, which I think I've quoted in other documents I had submitted to do this. The only thing that I, during the, for this is that there would be about 4 trees, maybe 5 that would be taken down because when you take the roots out, it's going to die anyways. And on that side, and that would give us some use because 50, I think it's almost 56% of the acreage that I bought is under wetlands and is non-usable. But yeah, I have to maintain it. So this will give a little bit to let us enjoy the land that we hope to play on there.
All right, I understand. If you want to submit this document into the record when you sign in, then I'll be able to review it.
Okay, well, I'd submitted everything else ahead of time. These are just copies
Okay.
I'd
If
said
it's
everything,
already in, then you don't need to.
you know,
Perfect.
on there. I just thought this would be a visual on there. The only other thing along with the variance, which I'm not sure if it really needs, but just, you know, you always want to dot your I's and cross your T's. This is the one submitted as well. If you look here on the, there's also a workshop, or I call it my play area, to be built, but it's just outside the wetlands, but still, I would rather it be considered so that if there's a variance, I'm not going to the Hillsborough County and they say, oh, you need a variance. So if it's all encompassed.
Well, what we're reviewing today is just the encroachment of your pool into that wetland setback.
Yeah.
That would be the only thing under review today.
So the, well, I put it all on the application just so if it's, because it's right close to the wetlands dividing line, shall we say.
Okay, but just to be clear, we're not going to review any other request as a part of this decision. It's only what you filed for, which is this encroachment into the setback for the pool.
Okay.
All right. All right. Does that conclude your presentation?
Yeah, that's about it.
Thank you, sir. If you could please sign in with the clerk's office. All right. Is there anyone that would like to speak in favor? Anyone in support of this application, either in the room or online? Seeing no one, anyone in opposition? No one. County staff, anything further?
No,
Mr.
nothing.
Joy?
Nothing.
Okay, perfect. Thank you. Sir, did you want to have the last word? Are you good? We close with you.
It's just that on doing this pool, that would give us some of the leisure use, like I said before, to use this, and it's been almost 2 years since I started this odyssey, and I'm hoping to get an okay with it so I can move forward.
All right. Thank you for that, your testimony. I appreciate it. And with that, we'll close variance 21-0605 and go to the next case.
Our next case is item E2, variance 21-0725. The applicant is Basilio Rizio, and they're requesting a variance to encroach into the wetland setback. Staff findings will be presented by Ryan Joyce.
All right.
Hi,
Mr.
Ryan
Joyce.
Joyce. Good morning. Ryan Joyce, Natural Resources. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown in the site plan submitted on June 1st, 2021, is to allow for construction of a portion of 2 new homes within the 30-foot wetland conservation area setback. Per the LDC section 4.01.07.B.4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within the required 30-foot wetland conservation area setback. The applicant requests construction of a portion of 2 homes in the 30-foot wetland conservation area setback. The applicant requests a 21-foot reduction of the setback to allow for a setback of 9 feet. With some findings with this, there is a previous encroachment for a portion of the existing home of 1,540 square feet, and that was done about 1984. However, no permits or variances for this request. Therefore, the existing encroachment is being included with this variance request. Of the 2 proposed encroachments, one has an encroachment of 21 feet, leaving a setback of 9, and the second has an encroachment of 20 feet 8 inches, leaving a setback of 9 feet 4 inches. A wetland compensation planting plan has been provided to compensate for the existing encroachment of 1,540 square feet and new encroachment of 1,406 square feet, for a total of 2,900 square feet. And that is all.
All right. Thank you so much. We'll turn to the applicant. Good morning. Sir, did you submit a copy of, I'm assuming this is a PowerPoint or something? All right. Did you submit a copy of that into the record? Okay. Do you have a copy you can submit into the record? Oh, it's, if you press the button, there you go.
All right. Thank you. Yes, I will submit it. I have a copy to
You have a
submit.
copy here you can submit?
I can
Okay,
submit it.
because just for this case and any other case, we can't take visuals off of a phone or a tablet because we have no way to submit them into the record. So if you have a printed copy, that's fine. You can
Oh.
continue.
Okay. I don't have a printed copy, but I could email it. Is it
No,
suffice?
after, when we close the hearing, then you can't submit any documents after
Okay.
that. You're welcome to describe whatever you'd like, but we can't use your tablet as a part of the presentation
Even-
unless you've submitted a copy of it.
I
into the record.
submitted a copy of the item that you're going to see here.
Okay.
Yeah.
All right.
Okay. So again, my name is Bezalel Israel. Good morning to everyone. And Madam Hearing Officer, to you and those under my voice. This is in regards to variance 210725 today in Judah Creek Estates. This is a quick background on where it's located in Citrus Park Village. The property in question here, the subject matter of the property is located in a red rectangle. To the right, you have Veterans Parkway. And to the north and south of the rectangle are 2 existing developments, mostly consisting of single-family homes. And the property to the south immediately is single-family homes as well, along with multifamily or duplexes. Interesting finding in it is that part of the property lands in flood zone AE, but also in conjunction with that, it also lands in the flood zone X, which I'm proposing the encroachment upon. Again, here, this is the item that was already submitted for this finding. So on here, we have on the left a darker gray to indicate this is the flood zone X area in which the majority of the houses lie upon. And on the right-hand side, we see the existing house that was so beautifully talked about by Mr. Joyce. So also on the right-hand side of that blue line, we have the line that's delineating flood zone AE versus flood zone X. So getting to the matter at hand, focusing on the encroachments itself, the compensation that I'm proposing are, of course, native Florida plantings in conjunction with dealing with the compensation needed in encroaching upon the land. The red line that goes through the property is the 30-foot setback line that is coming from an existing ditch. The ditch there has no name, as I was trying to find information on it, but as the information shows, I am also to maintain it as well. And with the 30-foot setback, we see what parts of the area it entails in taking upon the proposed buildings. So plantings along the edge to also help mitigate any stormwater runoff, and also in between and upon the areas of opportunity for biodiversity and rainwater collection, and also dealing with the type of plantings dealing on the ground. As the members in my community have raised concern that there will be a runoff into the ditch, in which they're totally independent from the property that I have. Properties north and south of me have been dealt with adequately by the civil engineers to deal with stormwater drainage into stormwater retention ponds located east of the property. And I'm not showing it on here because it wasn't submitted prior to you, so I'll leave that out of here. So north and south have independent, as proposed with any development, done correctly as though what they're supposed to do, dealing with stormwater runoff and stormwater retention ponds. In conclusion, just for the record, for those who under my voice for my community, there have been concerns that were raised by misinformation. No, I am not proposing to build multifamily houses. This is my dream home I'm proposing to build. And no, I do not propose to move the ditch. That is not my intention here today. Simply, my intention here is for actual request to encroach into the 30-foot setback. Thank you.
All right. Thank you, sir. I appreciate it. If you could please sign in with the clerk's office. All right. We'll turn to anyone that would like to speak in support. I have one person that I've noted that's in support online. Is there anybody in the room? Okay. So we have 3 people that want to speak. Good morning.
Good morning. My name is Lenin Bojorquez.
Pull this towards you a little bit. Thank you.
Lenin Bojorquez, and I reside at 14713 Rocky Brook Drive. So Mr. Israel would be my adjacent next door neighbor. Keep in mind, his property is 4 acres. So it's the longest one in the community, you could say. And just for the record, we were asked to sign a petition. So someone came to my door asking, we were all concerned, just as I should be as a citizen, as far as what is.
Excuse me, sir.
Yeah.
I'm sorry, but you please put your mask on.
Sure.
Thank you.
So in being asked, as a concerned citizen within Parkbrook where I live, to sign something that I was totally not sure what I was signing, I needed to get further details and insights. And that's when, I received a letter in the mail by Mr. Israel. And it talked about the wetland encroachment, but it was very I don't know what that means. Just like many of us don't understand what certain words mean. So it could be anything where they're going to move the ditch. Are they going to restructure the ditch? Are they going to build in the back? So there was many unknowns as far as is flood insurance going to go up, things of that nature. So that's when my son next to me, George, who's here with me, asked me, Dad, I see everything going on in the community. I see that big yellow sign in front of his property, in front of Del Valley Road. Why don't you just go talk to him? And I'm like, common sense. We're all adults. We're going through COVID. I said, George, I don't know how he's going to react. Maybe he's going to take it the wrong way. But I took his advice as a 12-year-old and went up to his door. Wasn't home. Left him a message. And sure enough, we were able to meet. And Mr. Israel was kind enough to sit down and explain to me what he was looking to do and build. Because of the fact that just like anything else, if you're going to buy a house, you're going to buy a car, whatever you're signing, you have to know what you're signing for. And that's why I did not sign the petition, because after I found out the facts, he's not moving this ditch, which is the runoff from the back of the property, Rocky Creek, and it runs off. Where it goes, I have no idea specifically. But it's on his property, and what he's looking to do is beautify, add additional value to the homes. And just for the record, the previous builder who built our homes, Pioneer Homes, was interested at one point in time to build 5 houses on his lot prior to him purchasing that home. I will leave it at that.
All right, sir, if you could sign in with the clerk's office, I appreciate you coming down. You were the person I had signed up in support virtually. So just to be clear, is there anybody else that wants to speak in support? All right. And then I have
a Sharon Gordon.
Okay, are you speaking in support?
Sharon, can you hear us?
Yes, sir. I don't know if you can see me.
Yes, we can.
I'm the other owner of the property, so that was my husband who just spoke.
Ma'am, can you state your name for the record?
Oh, yes, it's Sharon Gordon for 14807 Del Valle Road, Tampa, Florida. So I am the other owner of the property. So the property is essentially supposed to be a family lot. So that's something we've been looking for a few years. We finally found it because it has the zoning to support our family land that we've been looking for. So the house is on the land. The main house is my parents' house, and then the other one is of the family member, including myself and my husband. We are disabled vets, so a lot of the homes that will be built there will be very modern. It will match the other homes in the area as far as the aesthetic to increase the property values. And also, I think as another lady mentioned in the first hearing, she was saying that was the tax for the county. So for us, it was just a beautiful plot of land. We had no intention of doing anything in the back, no intention or rerouting the ditch, but only to do it for the property and just have a land for our family and for our children. I believe that's all I have.
All right, thank you for that. I appreciate you participating. All right, so now we'll turn to anyone that would like to speak in opposition. I have one person signed up virtually. Is there anyone in the room? Yes, ma'am, if you'd like to come forward to speak in opposition. While she's coming forward, is there anyone else in the room that wants to speak against this? All right, if you could start by giving us your name and address, please, and just pull that microphone down to you. Perfect.
Thank you. My name is Janet Stanko, and I live at 14701 Rocky Brook Drive. And I'm in close proximity to the subject property. This document has been previously submitted. I represent 55 homeowners in the area who have signed on to a letter of objection. And we originally had about 12 or 13 that are in close proximity along both of those communities. And then the rest are from the Park Brook subdivision. We are against the variance for 2 reasons. One is we maintain that there is no hardship involved in complying with the requirements as they are, and we do have some environmental concerns. The property is, as you can see, very long and skinny. And it's only about 156 feet wide. So there isn't really much, there's a close proximity to the adjacent neighborhoods. And in fact, Rocky Creek subdivision is right adjacent to the subject property. At the south end is Park Brook, which is separated by, I think there's like a public easement, a 2-lane access road, and then another public easement. So there's a little bit more distance there. But as you can see, these properties are in very close proximity to where they plan to build, which is right here. We maintain that there is no hardship because the applicant purchased this property in August of 2020 with the knowledge of the wetland setback around. Now, they call it a ditch. I think it can be referred to as a creek, but it is a viable conduit of water that goes from the wetlands at the west under Del Valle Road and then goes to Rocky Creek. So this is an important conveyance of water. And as such, it has a 30-foot wetland setback on either side of the I'll call it a creek. The wetland setback is not a new restriction. It was there when they purchased the house, well before they purchased the property. Two developers looked at it, the developer of Rocky Creek and the developer of Park Brook. And both of them backed away from developing that, we think because of the environmental attributes of the property. We have looked at some prior cases, similar cases, and I've given a full citation in the the paperwork or the objection that we filed on June 7th. So I'm not going to go into the details of the citation, but here's a couple statements from some similar type court rulings. Appellants are deemed to purchase the property with constructive knowledge of the acceptable land use regulations. A subjective expectation that the land could be developed is no more than an expectancy and does not translate into a vested right to develop the subject property. Another statement or another ruling says neither purchase of property with zoning restrictions on it, nor reliance that zoning will not change will constitute a hardship. So we feel that there is no hardship here because there was full knowledge of the requirements for the wetland setback. Now, the other part of our objection is environmental protection. First of all, the purpose of a conservation easement is to protect the water quality from runoff from the yards. Because the runoff goes into this creek that goes into Rocky Creek. Under the proposed variance, the 30-foot buffer will be eliminated, and native plants are proposed in lieu of the part of the buffer that's impacted. It may not be the whole wetland buffer, but there is an impact. And native plants are proposed, but we know that when people move into a property, they have their own ideas of how they want it to look, and they replace native plants with grass and conventional landscaping. So there's no guarantee that those native plants will be there to do the job. Also, we know that the owner will elevate the level of the footprint of the house to comply with building requirements. That there's 3 large houses that will go in this small area here. The elevation of the land along with the non-permeable surfaces related to the building will create more potential for flooding onto the adjacent neighborhoods. There's a concept called development-related flooding, and that results from displacement of water due to fill and impermeable surfaces that accompany homes and the driveways and resulting driveways. And that flooding can happen when there was no previous flooding just because of the displacement of the water. And this is a part of our concern. There are already flooding related issues in the area. I've been told that during the tropical storm related to Hurricane Irma in September of 2017, Del Valle Road was flooded and it was unsafe for vehicles to pass. Residents of the Rocky Creek subdivision there, north of the subject property, can only access their subdivision by Del Valle Road because there are no other roads that are through roads that access their subdivision. These people are concerned that they will not have any access to their property in case of a flood event. Our question is, how will flooding on Del Valle Road be impacted by raised elevation and reduced impervious surfaces with the proposed development? Where will the water go? And there are already 4 retention ponds in the area, in this area back here, bordering the east end of the property. So will more flood retention, or will more water retention ponds really be effective in moving water away quickly? We think not. We believe that the variance, approving the variance, will substantially interfere with or injure the rights of adjacent and nearby property owners who would be affected by flooding impacts. Another point is that the owners talk about how they plan to provide housing for their family. Well, there is nothing that prevents them, once they have their approvals in place, from flipping this property, either immediately after getting their approvals or after building the houses. So I think the assertions that the family will live there really has no bearing. And it has no bearing on our objections, because our objections are that there is no hardship and the environmental impacts would threaten the adjacent neighborhoods. The 55 property owners in the adjacent neighborhoods are relying on environmental regulation and Hillsborough County officials to protect our neighborhoods. As one property owner put it, I purchased this home as my forever home, so I care about what happens now, not only now, but 5 or 10 years down the road. So we ask that this variance be denied. Thank you for the opportunity to speak.
Thank you for your testimony. If you could please sign in. Ms. Snako was the only person I had signed up. By seeing no one else that wants to speak in opposition, we'll go back to county staff to see if they have any additional comments.
I would just like to add that they would be required to submit an annual report for 2 years.
Sign in.
For the compensation plantings, while it's not in perpetuity, but it would be a requirement for 2 years for the monitoring report, if that helps with their environmental concerns.
All right. Thank you for that information. Sir, you have 5 minutes for rebuttal.
So it was interesting to hear that Ms. Stanko mentioned the letter of objection, and most of the testimony by her, which seemed to me a lot of assumptions. She said based off 55 she's representing, and a lot of that was signed by the 12 or 13 or so applicants was based up mainly on misinformation predicated by fear. Obviously, anyone living in any conjunction of any body of water, especially here in Tampa, does not want to be flooded out. Also, on the record, I am indeed the architect of said property, and these are the designs of myself. And being an architectural designer, it is my duty to also make sure I deal in conjunction and harmony with nature, as I share the same concern with her and the rest of her community. So, flooding, again, the civil engineers of each development has surpassed how to handle stormwater flooding on their own adjacent properties. And she so adequately said that the retention ponds, and she pointed to the left instead of the right, the retention ponds are indeed located on the east side and not adjacent to Del Valle Road. Potential flooding, again, flooding does not occur along Del Valle Road from my property. Any flooding will run up into the said ditches running east and west into Rocky Creek that's located on the east side of the said plan. And she also mentioned purchase with the pre-knowledge. I would surely like to know how she come about this information when we purchased the house, as though she was not with us during the time when we purchased it. There was no pre-knowledge of purchasing the house. That knowledge came about while residing there and talking to adjacent neighbors. Again, I don't know where she gets this information from. And it's interesting to say we think we're dealing in a world that we need to know before we make assumptions. Again, the east end retention pond is totally, not to be unduly repetitious, on the east side, not connected to Del Valle Road. And flipping property. This is another assumption. I don't know where she's getting this information from, but my forever home, like the comment or the statement made by the concerned community member, living 5 to 10 years from now, I will hope he want to stay longer because I planned on dying here. This is my forever home, my dream home. And not many architects get the opportunity to do so. So in closing, I ask that those who are hearing my voice, who may not have spoken with me and took upon the opportunity like Mr. Borquez did, to speak to me in person. They have my number, call me. I'm an open book and I'm transparent. Again, do not base it off assumptions or fear. Let's base it off facts. Thank you for your time.
Thank you for your testimony, sir. With that, we'll close variance 21-0725 and go to the next case.
Our next case is item E3, variance 21-0829. The applicant is Sam Arif and of Arefco International Incorporated. They are requesting a variance to encroach into the wetland setback. Staff findings will be presented by Ryan Joyce.
Ryan Joyce with Natural Resources, Hillsborough County. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on May 14th, 2021, is to allow for construction of a retaining wall and service road with 30-foot wetland conservation area setback. Per LDC section 01.07.B.4, no filling, creating, or placement of permanent structures or services shall be allowed in a required 30-foot wetland conservation area setback. The applicant requests construction of a retaining wall and paver service road wetland conservation area setback. Applicant requests a 25-foot reduction of the setback to allow for a setback of 5 feet. There's two opportunities. Compensation planting has been provided to compensate for the proposed 12,981.18 square feet. The construction of the retaining wall and access will require a that is all.
All right, thank you so much. Is the applicant here? Good morning. You could bring that microphone down to you, and I don't think it's on. There you go. And give us your name and address, please.
Good morning, Sam Aref,
13250 North 56th Street, Suite 202, Tampa, Florida. Yes, I'm here representing Dr. Kiran and Dr. Pallavi Patel, which she's here. She may want to say something later on. So this variance request is to reduce the 30-foot wetland setback buffer from 30 feet to 5 feet. And the reason for that is we're proposing a service road to service the structures on the east side, and that is to take care of any utilities on the roof, such as AC and others, and also maintain the facade of the building on the east side. Now, with that service road, because of the terrain change and the elevations, a retaining wall would be required to hold the soil back. The wall will vary in height. This is not a typical section of the wall, but just cross-section taken at a specific area. And here's the structure with an elevation of about 47 feet. And the wetland area, the wetland elevation is about 35, 36, 37 and about. So we're proposing a grass strip just outside the structures with a 15-foot service road and another grass strip and then the wall. And the reason for the grass strip right before the wall, really two reasons. One is safety concern, and other to capture any pollutant loading on the service road before it gets to the wetland through the filter fabric shown on the cross section. Now, one will ask, why would you need a 15-foot service road? The equipment that will be used to service the building, those are large forklifts that will be required. And I have some pictures that I will submit later. They were not part of the application. Not having the 15-foot service road will create hardship for maintenance. And as this forklift showing, that wheel toward the grass is that 15-foot from the wetland line. The 30-foot is on the other side of the tire that's close to the building. So that creates hardship if we cannot, or if the variance is denied. The other, I have some more pictures that will show. Here's the true operations of how the facade of the building on the east side will be serviced. Now,
If you could include in your presentation, because I believe I'm familiar with this house, the square footage, the total square footage of the house and the height of the structure?
the height of the structure is 45 feet. The square footage of which the building or the what?
The building,
The square footage-
approximately.
$82,000 square feet.
All right, thank you.
With a height of 45 feet.
Thank you.
So that forklift is required. It has a reach of maximum 65 feet. And as you see, it's very hard to get to with that, with the hardscape in front. We looked at other alternatives to see what other equipment that's narrow, that we do not have to use it. We looked at scissor lift,
we had an incident on site that the scissor lift flipped because it's narrow and not as high. It shattered the glass. We also looked at scaffolding, which would be a nightmare for maintenance, continuous maintenance for the facade, and you cannot carry load up to the roof of the building in case there will be some unit change like AC and others. So we looked at that. Now, we received calls, about few calls, 6 to 7 calls, people concerning why are you building this wall? I think the concern was the wall was going to be high and it's going to block the view. So I assured the callers, and that's why I'm stating here again today, that the wall is going to be a short wall, and the purpose of it is to just hold back the soil for the construction of that service road. I believe people were satisfied and assured them it would be about 3 to 3.5 feet maximum. It could go down to 2 feet, depending on the terrain. Now, this wall is inconsistent with the surrounding areas along the lake. There are many properties with seawall. This is a retaining wall, which is 5 feet in. It serves the house. Without it, or the structure without it, there would be, again, like I said, hardship for not maintaining the property properly. That's what I have, unless you have other questions.
No other questions at this time. And you can submit your documents when you sign in with the clerk's office. Thank you for that. I appreciate it. All right, we'll call for anyone that would like to speak in support. Anyone like to testify in support? I don't have anybody virtually. Yes, sir. You give us your name and address, please.
Yes, my name is Dr. Donald Richardson, Ecological Consultants, 5121 Ehrlich Road, Suite 103, Tampa, Florida. I'm the environmental consultant for this project. And I'd like to add a couple things if I could. I was asked to put together a compensation plan for the impact area, which you see in blue. The property limits are basically the green area, and the Patels are building 3 large homes on the west side of the lake there. So, excuse me. From what I understand, when this was originally permitted, there was not a service road. So the 30-foot buffer impact was not an issue at the time. However, once the house now is being finalized, we don't have access because of courtyards on the east side of the house. So they've had to add a service road for everything from catering to roof maintenance to facade, pressure washing, almost everything. And one of the important issues that I had was EMT and fire rescue access. Because right now, without that service road, there's no access to the east side of the building. So in essence, the impact to the buffer is, as Sam said, the little green area is the 5 feet that is to remain. The buffer wall will be a stacked wall, rebar with a footer, about 4 feet high, so that they'll be able to get equipment and or EMS by the structures that you see on the building. Now, the owners have this 5 foot little narrow area there. We can also plant the remaining part of the buffer in green that is to the south of the homes. So we have, and that if we plant all of that buffer, we're in excess of about 1,000 square feet. So the issue here, to me, the addition of a stem wall reduces any secondary impacts to the wetland. In addition to that, the owners have planted the littoral area of that side of the lake, which reduces fetch and reduces erosion. So we now have littoral plantings, 5 feet of grass, and a stem wall. Well, if we didn't have the stem wall, because of the elevation differences, we would have 4-to-1 slopes. So we would have approximately 20 some odd feet of slope, which is grass. So the stem wall will reduce any traffic, any fertilizer, because all the drainage from the roadway has to go to the west and not into the lake. So even though we are impacting the buffer, we're not providing any negative effects to the lake because we've planted it, which is nutrient uptakes. We're also going to plant with native plants the remaining portion of the buffer, and then the wall will reduce any further secondary impacts. That's all I have.
All right. Thank you for those comments. I really appreciate it. If you could please sign in with the clerk's office.
you.
Anyone else that would like to speak in support? Seeing no one, anyone in opposition to this request? Seeing no one online? All right, Ms. Would you like to speak in support? Oh, yes, sir. Yes. Just give us your name and address, please.
Hi, my name is Varun, and my address is 5608 Pinnacle Heights Circle, Tampa, Florida. I'm going to show it on my phone. I'm not going to support it, and I think it's just for anybody sitting over here or wants to understand, and for yourself to see the property when they show it in the drawing.
Sir, before you do that, were you here when we talked about showing things off a phone
Yes,
or a
I did.
tablet?
Yes.
If you've submitted it into the record or it's already in, then
Yes.
then feel free. But if it's not, then we can't discuss it. We can't show it because you can't submit it into the official record.
Okay.
But you're welcome to describe whatever you like.
Right. So I just wanted to point out the last building over here, which we have already submitted. And the photos you have seen, the boom lift was sitting right next to the corner of the building, which had only like 2 feet from the existing structure. And our 30-foot wetland buffer is about 2 feet from there. So as Mr. Sam was explaining and Mr. Richardson said, this picture right there shows you how much space do we have from the building to the wetland, and the request of what we are making right now. Oops.
There you go.
And the request we are making right now for the 5 foot is for the big boom lifts to go. At the 45 feet, when the guys go up, as he mentioned earlier as well, the scaffolding is not a practical, and with 3 buildings and a magnitude of this height, every now and then there would be services, there would be equipments coming in and out, and it would be very difficult to handle if we don't have enough space from the equipment to the height of the top of the buildings. So that was one of the points we wanted to make sure it is considered while you make a decision for us.
All right. Thank you so much for that additional testimony. If you could please sign in. We're at the clerk's office, sir. All right. So we went through opposition. Mr. Joyce, anything further you want to add?
No, there's nothing.
All right. Mr. Arif, you have the last word if you'd like. You have 5 minutes for a rebuttal if you'd like to take it.
Really, the only thing I say, I welcome you to go to the property and see the restricted area for the intended operation. And we hope you approve it, and we just appreciate your time.
All right. Thank you for your time and testimony. I appreciate it. With that, we'll close variance 21-0829 and go to the next case.
That concludes section E of the agenda. Takes us to section F, sign variances. We have one case, item F1, application 21-0729. The applicant is Dr. Mohammed Halal, requesting a sign variance. Staff findings will be presented by Kim King.
Good morning.
Good morning. Kim King, Development Services. Good morning. The applicant is requesting a, I'm sorry, I'm hearing two different conversations.
Can you hear us?
I can hear you, but it's repeating everything.
Do you have another application open? Like, are you watching on YouTube?
I will tell you, I had to come to someone else's computer because mine, my screens went black. So I'm using someone else's computer.
Do they have their speakers on?
Tim, do you have your speakers on? I'm checking.
That's why. Seems to be on. See if that's.
Can you hear me now?
Yes, we can.
Hello?
Yes, can you hear us?
Okay. Okay. Let me try it again.
Okay. And if that doesn't work, I suggest maybe logging back out and logging back in. Maybe
Okay.
we'll reset it.
Okay, it's still doing it. Do we want to move this to?
So
It's
we're not
still-
hearing anything on end. You're coming in clear on our side.
Everything is repeating. Okay, I think it'd be best if I signed out and signed back in.
Okay.
In the interest of time, maybe we should hold this one and we'll take the next case and come back to Ms. King.
All right, we're going to move to section G then. These are the general variances requests. First case is G1, variance application 21-0305. The applicant is Orlando Huertas, requesting a variance to lot development standards. Staff findings will be presented by Kevin DeFrank.
Good morning, everyone. Kevin DeFrank with Development Services. Now, for this case, may I continue?
Good morning. He just went to the restroom.
Mr. DeFrank, the applicant goes first, so he'll do his presentation and then it'll be your turn. So you have a minute. Thank you, though. I appreciate it. Go ahead, Mr. DeFrank.
So yes, the applicant will go first, right?
No, sir. You go first.
Okay, I go first. Okay. So for this case, the applicant is requesting setback variances to accommodate existing additions to a single-family home on property zone RMC 20. And for the record, I think I'm hearing the feedback that. Can you guys hear me clearly?
Yes, we can.
Okay. So I would like to highlight for the record that in the report, there is a typo under the variance section where it states RMC 16, RMC-16, it should be RMC-20. But per the Land Development Code, the minimum required setbacks in the RMC-20 district are 25 feet for the front yard, 10 feet for the side yard, and 20 feet for the rear yards. And specifically, the applicant requests a 3-foot reduction to the required front yard to allow a setback of 22 feet from the north property line, a 5.4-foot reduction to the required side yard to allow a setback of 4.6 feet from the west property line, and a 1.1-foot reduction to the required side yard to allow a setback of 8.9 feet from the east property line. And our staff findings include that the RMC-20 district requires a minimum lot width of 70 feet. However, the subject parcel property has a width of 50.07 feet. However, it has been certified as legally non-conforming and subject to the building coverage and setback requirements of the RMC-20 district per the NCL 21-0784, which is in the case record. In addition, the applicant also submitted an administrative waiver application 20-0289, which sought to allow a reduced front yard setback of 22.17 feet and reduced west side yard setback of 4.5 feet, which the waiver was denied for the decision letter. And lastly, no variances have been requested by the applicant to other development requirements. Thank you, and I'm available for questions.
No questions at this time. Thank you. Now we'll go to the applicant. Good morning. I think you need to turn on that microphone. There you go. Perfect.
My name is Orlando Huerta. My address is 1109 East 140 Avenue, Tampa, Florida 33613.
Thank you.
If no speak English, speak my wife.
Okay, perfect. Just give us your name and address as well.
Yes.
Bring it down to you a little bit. There you go.
Good morning. My name is Julia Vega, and we're 1109 East 140th Avenue, Tampa, Florida. And we had put in a request for the variance for the setbacks on that property. He purchased the home in 2017, and we actually were all new to this, so we inherited a lot of headaches, but we finally got to the variance application, and thanks to Mr. DeFrank that he's helped us so much. We look forward to getting this approved since we had submitted plans for after the fact permits. The property was already the way it was. We just replaced the fence that was already there. So other than that, we're expecting for approval since everything else got approved, and this is the last thing that we're hoping to do. We needed to reinforce the fence due to the fact that we have a disabled child, which has transportation from the EMS for her appointments and everything else. She has severe cerebral palsy, and nurses come over. The ambulance is constantly there, and we needed this property updated when we first got it. We didn't know that we had to submit for permits or anything like that. We did it, and after the fact, we submitted for the permits. Everything else has gotten approved except for the setbacks at this time.
All right. Thank you. I understand. Thank you so much. If you could both sign in with the clerk's office, I'd appreciate it. All right. Is there anyone that would like to speak in support? Anyone that wants to speak in favor? Seeing no one, anyone in opposition to this request? No one. County staff, anything else?
No, ma'am.
Nothing further.
All right. If you don't have anything further, then we'll close variance 21-0305 and go back and ask if Ms. King is up and running. We can take that prior case.
Ms. King, are you there?
Kim, are you logged in?
Okay, well, let's keep moving then. We'll move her to the end
Great.
and
All
then we'll keep going.
All right, so we're going to move that one to the very end?
Yes.
Okay, let me just make note of that, please. At the end of the variances then, or the end of the entire hearing?
We'll do it at the end of the variances. We'll try,
Okay,
we'll try
great.
again.
All right. Give me 1 second to note that, please. Okay. Our next case then is item G2, variance application 21-0403. The applicant is Jose Milagros Carreno. Our request is a variance to lot development standards. Staff findings will be presented by Chris Grangelard.
Good morning. I'm Chris Granlenard, Development Services. I'm here to present application variance 21-0403. The applicant is requesting a setback variance to accommodate a proposed rear addition to an existing single-family dwelling on property zoned PD 75-0310A. The conditions of approval and general site plan for PD 75-0310A do not identify the required minimum building setbacks for the subject lot. However, staff has determined the required setbacks are as follows: front 20 feet, side 7.5 feet, and rear 23 feet. The applicant requests a 14.5 reduction, a 14.5 foot reduction to the required rear yard to allow an 8.5 foot setback for a proposed addition to an existing single-family dwelling. Findings: the existing single-family dwelling is utilized for a community residential home, type A, with 6 or fewer placed residents. The home was the subject of a variance 20-0766 last year in 2020, which sought to reduce the required 1,000-foot separation from 2 existing type A community residential homes located at 2203 Shermont Place and 704 Overhill Drive. Additionally, variance 20-0766 sought setback variances for an existing accessory structure in the rear yard of the subject property. The variances were approved. Also, variance 20-0766 also requested a variance to allow a 24.6 foot front yard setback for the existing dwelling on the basis that a 25-foot setback was required pursuant to RSC 6 standards. The setback was approved. However, staff has determined in its review of the present application that the 25-foot setback is not required on the subject property, rather that the required front yard setback is 20 feet, actually. That concludes my staff report for variance 21-0403. I'm glad to answer any questions you may have. Thank you.
Excuse me. I don't have any questions at this time, but thank you. Is the applicant here? Good morning.
Good morning. My name is Milagros Carreno. Address is 2205 Shermont Place, Brandon, Florida. And variance 210403, it's proposing an approval request to reduce our rear setbacks from 23 to 8.5. Here's a copy of our property survey. In the square, it shows the proposed area. It's 18 by 38.5, which is a total of 693 square footage. Reasons that support our proposal is that we currently own and operate a 6-bed community bed assisted living facility, and reducing our setbacks from 23 to 8.5 will allow us to expand and build a larger dining area, common area, rehabilitation area for our residents. The proposed variance request will also allow our residents to have more space for visitation in a more private area setting. And it will also give us an opportunity to have more physical and occupational therapy in that section in the back area. Additional reasons, we've always been in compliance with ACA. 0 deficiencies during our health and fire marshal inspection, 0 complaints. We are 5-star reviews on Google. And that's it. Closing, the proposed request will allow our residents to have more space in a home-like environment. Our hope is to continue to provide services for the elderly in a safe environmental residential home. This proposed request does not impose any hardship on any neighbors, nor would it serve to create a situation where any neighbor's quality of life, property of value, or peaceful coexistence will negatively be affected. And lastly, our goal is to preserve public health, safety, and comfort and welfare to our senior community. We did speak to our neighbors. We have a great relationship with all of them. Our backyard neighbor says it's fine with it. He also signed initially a letter that was submitted initially. And that concludes everything. It'll be greatly appreciated if we get that approved.
Just one quick question, for the record, to make sure you're not increasing the number of residents.
No, we're not.
This is just an additional area for the system.
Yes,
All right.
yes, ma'am.
Thank you both so much. If you could please sign in with the clerk's office.
Sure.
All right. Anyone that would like to speak in support of this application? Seeing no one. Anyone in opposition? No one. County staff, anything else?
No, ma'am.
All right, then with that, if you don't have anything further, we'll close variance 21-0403 and take the next case.
All right, next case is item G3, variance application 21-0498. The applicant is Roy Mazer, and they're requesting a variance to lot development standards. Staff findings will be presented by Kevy DeFrank.
Good morning again, Kevy DeFrank with Development Services. For this variance case, the applicant is requesting a setback variance for a proposed addition to an existing building on property zone SPI-AP-5. And per the Land Development Code, the minimum required front yard setback in the SPI AP5 district is 30 feet unless, per in note 17, the parcel fronts on a collector or arterial street as shown on the Hillsborough County functional classification map with a right-of-way width of less than 175 feet, in which case a minimum front yard setback of 50 feet is required. And in the subject case, the south side of the subject parcel abuts Sly Avenue, which at this location is an arterial street with a right-of-way width of approximately 82 feet. Therefore, a minimum front yard setback of 50 feet is required from the south property line. And specifically, the applicant requests an 8-foot reduction to the required front yard to allow a setback of 42 feet from the south property line. And in our findings, the applicant has clarified and confirmed that the subject building serves as a warehouse and also houses telecommunications switching equipment. And that concludes my report. I'm available for questions.
No questions at this time. Is the applicant here?
This is Clint Couple with WRA. I took over for Roy Mazer this project. I do have a representative there that has some handouts that I'll be presenting, if that's okay. I'll present it from my screen, but if it's okay, he has the printouts of what I'll be presenting, if that's okay. Can everybody hear me okay?
Yes, I can hear you.
Can you also state your name for the record?
This is Clint Couple with WRA.
All right, and your address, sir?
4260 West Lineball Avenue, Tampa, Florida, 33624.
Thank you, sir.
Thank you. So this project is an existing telecommunications switchgear for T-Mobile. It's got some warehouse components. So I'll go through kind of the history here. Here's the proximity map. It's the property shown in yellow. It's been there. It's constructed 38 years ago. T-Mobile and its affiliates have access to the building since then. And so a good summary of this project is they need to do, telecommunications cell phone business is forever expanding and changing. with technology. So they need to do some retrofits to the existing building to house some new equipment that they need for the area. This is a major hub for them. In order, if they don't get this, they have to move locations. So we go into further detail here on exactly what we have. The building, like I said, is constructed 50 feet from the right of way as of now. This industrial park, the whole park in the area has been in place since '96. The expansion, he says, proposed is necessary to keep the, keep the new equipment that they're going to be expanding in the facility to keep up with the new cell phone age of all the technology. Through a couple pictures here. So there's a couple areas on the site that we looked at doing the expansion in a couple different areas. And to the west, we have the existing swale stormwater pond, which is what you see here in the west. On the east, we actually have another road on the east that has a building setback, and all this, the way the building's configured, expanding to the east was not a viable option for them. Out front, we have an existing fairly large ditch system along the north side of Sly Avenue. So here's another good picture. The property boundary is 42 feet or so from the edge of pavement of Sly. It's set back very really far off the road as it stands. The building you can see back there in the back. Show the site plan. I think it's the best way to describe it is with the site plan here. So the building expansion, like I was showing, Sly Avenue is out here. There is a right of way. So the edge of pavement of Sly is set back 40-something feet from the right of way. And then the building right now is 50 feet from there. So the gray is the existing building. And this is how they would like to expand. We have expansion back there in the back, expansion in the front. Probably going to need 42-foot front setback, which is what we're requesting is an 8-foot reduction in setback. Another thing to note is we do have some large oak trees out front that the design we're doing is we're taking into consideration. We've got root pruning shown, so we're not planning on taking out any trees. There will be some pruning of the trees, but the goal is to not take out any of the trees out front. There's existing micropresentation here. You can see along Sly, there's existing, like for example, this structure is well within the 50 feet of the setback, and there's multiple warehouses and industrial park structures that get well within the 50 feet. So based on what we're proposing, in order to keep T-Mobile in this facility, they need these expansions. We need to request the 8-foot front setback from 50 to 42. And I'm here to answer any questions that you may have.
No, you answered my questions. Thank you so much. I appreciate it. All right, we'll go to anyone that would like to speak in support. Anyone in favor of this application? Seeing no one, anyone in opposition? No one. County staff, anything further?
No, ma'am.
All right, and sir, if you have anything to add, you get the last word for rebuttal.
I think I'm good. I appreciate you.
All right, thank you for your time and testimony. Oh, excuse me. All right, thank you for that. With that, we'll close variance 21-0498. I see it's noon, so let's take a 5-minute break to give the court reporter a break. So by the clock on the wall, we'll be back at 12:05 and resume the hearing.
Ms. Dorman, can you hear me? Oh, sorry. Kim, can you hear us?
Yes, I can hear you.
Okay.
It wasn't your normal feedback. It was.
I can hear you. I'm
Okay.
sorry.
Perfect. So you don't have any feedback right now, right?
No,
Thank you so much. We are now resuming the land use hearing officer hearing, June 21st. Mr. Hisney, we're ready for the next case.
Okay, that would be item G4, variance application 21-0549. The applicant is Evan Childs, requesting a variance of lot development standards. Staff findings to be presented by Isis Brown.
Good afternoon, Isis Brown, Development Services. This is variance 21-0.
Isis, we can't hear you.
We can hear you. It's just very low.
Is this better?
Give me another test, please.
Testing. Isis Brown, better?
That's good. Thank you.
Okay. Good afternoon, Isis Brown, Development Services, variance 21-0549. The applicant is requesting a variance to the required front yard setback to accommodate a proposed single-family dwelling on a lot zoned ASC1, agricultural single-family conventional. Per LDC section 6.01.01, a minimum front yard setback of 50 feet is required in the ASC1 district. The applicant requests a 20-foot reduction to the required front yard to allow a front yard setback of 30 feet from the south property line. Staff has found that the lot is non-conforming, legally non-conforming per NCL 21-0689. In the ASC zoning district, the lot is supposed to be a minimum of 1 acre. The lot is currently 0.73 acre in size, and 0.58 acre of uplands is required. As stated before, per NCL 21-0689, the lot has been found legally non-conforming and is in the case records. I'm available for any questions.
No questions at this time, but thank you. Is the applicant here? Good afternoon. Good.
Sorry. Evan Childs. I don't have a formal address, but I do have north side of Cosme Road, approximately 548 feet east of Gun Highway. As you said, we're looking to build a house, and essentially what this is going to give us is 20 foot closer to the road, where our house depth will be larger than a garage bay. I'll submit this. It's already been submitted, but just for a visual. There we go. So you can see our lot's pretty wide. So yeah, we don't have much. We just want to be able to build a normal looking house and not make it extremely wide. We're looking to avoid the wetlands in the back. We don't want to encroach, so we found it more easier, I guess, to be closer to the road. So yeah, we're just trying to avoid the wetlands.
All right. Well, thank you for that. I appreciate it. If you could please sign in with the clerk's office, and if you'd like to submit that into the record, I know you said it's already there.
I believe it is, but either way, we have our survey on.
Perfect. Thank you so much.
No problem. Thank you.
Is there anyone that would like to speak in support? I don't see anyone online or in the room. Anyone in opposition? No one. County staff, anything else?
No, ma'am.
All right. Then with that, we'll close variance 21-0549 and go to the next case.
Next case is item G5, variance 21-0688. The applicant is Jack Bartlett. The request is to eliminate a required sidewalk. Staff findings will be presented by James Ratliff.
Good afternoon.
Good afternoon, Madam Hearing Officer. For the record, James Ratliff with Development Services Transportation Review Section. The applicant for variance petition 21-0688 is seeking to waive required sidewalks along the parcel's roadway frontages. The subject parcel fronts on Clarksdale Lane for a distance of approximately 180 feet and fronts on Centerbrook Drive for a distance of approximately 510 feet. I would note that there is an error in the staff report in the table titled variances under general description. It states that this is a variance from the requirement to construct internal sidewalks. I suppose that depending upon how you look at it, this is internal to the subdivision or external relative to the individual parcel. So that should probably state external, or really better yet, it should just state variance from the requirement to construct required sidewalks. I went through, noted in our staff report, how in staff's opinion, the applicant failed to meet each of the 6 required criteria, and as such, we recommend denial of that variance application, and we'd be happy to answer any questions you have.
Now, I've read your responses were very thorough, and I've read all of them, so no questions at this time. Is the applicant here? Good afternoon.
My name is Jack Bartlett with Bartlett Custom Homes. I understand the need for 1511 South Miller Road. Sorry.
Thank you.
I understand the need for sidewalks and have built many in required areas. I've been building for 35 years. I'm pretty sure I know what's going on with that. In this case, we didn't find out that we needed the sidewalk until we went to get the road permit. We believe there was no reason prior to that we would even need one, because there's not a sidewalk in the subdivision that has 84 completed houses out of 85. The Homeowners Association bylaws states that the sidewalks are not required in the South Oak community. I have built houses in there before and never had to put a sidewalk in. We are requesting a variance in this instance because of the following. This is the last house in the development. There are no other sidewalks. There is no one going to have a sidewalk. This poses a safety issue. It is in the very back of the subdivision. It's not even in the front. Within the last few years, there have been some houses that have been built in there. No requirements for the sidewalks. When they say that this has been in existence for 15 years, well, I don't know why they didn't catch those two. It's basically a sidewalk to nowhere. We've sent notices to the homeowners, and they're in support of no sidewalks. There hasn't been one in there. They don't want one in there. We understand that the pedestrian safety needs addressed in high traffic areas and high pedestrian areas. This is not one of those cases. This community's been there since 1981. It has functioned safely without needs of sidewalks, even in the community continue to grow and develop. That's basically all I have, and I'd like to turn it over to Dr. Eccles, the homeowner.
That would be fine. Let me just ask you a quick question. You mentioned you've built other homes in that subdivision.
Yes.
Approximately how long ago?
Probably like 20 years ago.
20 years ago. Okay, thank you. And you said this is the 85th home?
This will be the last home built in the subdivision. Everyone is done except for that one.
All right.
That I know of. I mean, there could be, I don't think there is, but I've looked.
All right, thank you, sir. If you could please sign in. Good afternoon.
My name is Eddie Eccles. I presently reside at 10818 Barbados Isle Drive, Tampa, Florida. And my wife and I are in the process of building, or have just about completed building the house at 603 Central Drive. To kind of reiterate what Mr. Bartlett has said, this is a very mature neighborhood. Pretty much all the parcels are gone, such that our understanding is that this ordinance was designed to improve urban access via walking to various locations. As Mr. Bartlett has eloquently stated, our home is in the rear of this neighborhood, which has one entrance and one exit. Therefore, to get to our home and the required sidewalk would require about a mile or so before you actually got to it. And as far as additional buildings being constructed to allow for subsequent then sidewalk to be completed by others, as we stated, there are no more parcels in the neighborhood to be constructed, so that the chances of there ever being additional sidewalks built is minimal at best. The other thing that I would like to bring up is that we live in a very mature, older neighborhood, as Mr. Bartlett stated, such that a lot of our neighbors are up in age. And so really, I feel that the construction of this sidewalk can actually cause a safety hazard, because as individuals are walking now, then that will require them to adjust height to go up on our sidewalk. And there have been instances in the past where individuals have fallen on such sidewalks. And once again, being more senior of age, that leads to significant fractures and significant comorbidity. So in a scenario such as this, where really we don't think the placement of a sidewalk is going to meet the intent of the ordinance, it appears that it really is going to cause more of an impairment and potentially more of a problem. Also, as Mr. Bartlett indicated, there have been other homes that have been constructed, in the area since this ordinance supposedly was on the books and were not required to have a sidewalk. And then finally, we want to come to this neighborhood and be accepted by our neighbors. And actually, we've got a lot of support. I think you've seen some of the documents. They obviously are not in favor of a sidewalk, as there are no other homes that have a sidewalk. And at this point, it would appear that this sidewalk to nowhere would actually be more of an eyesore and could potentially decrease values. And so our neighbors are not in favor of it. And we don't want to come into a neighborhood, be the outliers, and cause problems. We like to be welcomed into the neighborhood. And that's all I have.
All right. Thank you, sir. I appreciate it. If you could please sign in.
Thank you.
With the clerk's office. All right. For now, I have, we'll take testimony and support. I have 2 people signed up online. Is there anyone in the room that wants to testify in support? All right. Well, then let's take those folks that are online. Give us your name and address, please, first.
Ms. Cook?
Yes, my name is Pat Cook. I live at 610 Centerbrook Drive here in Brandon. I just want to read to you actually what I submitted earlier. As a member of our Homeowners Association Board of Directors and a resident in the South Oak community for 33 years, I would like to voice the concerns of the community, as well as my own concerns, in support of granting this variance. Our community has been in existence since the early 80s. We are a community of 84 homes with large acre and upsize lots, and this provides a country setting that we've worked hard to maintain. There are no sidewalks, as has been already pointed out, along the road running through our community. There's only one entrance, one exit, so we don't have through traffic, which really makes it a very safe community to live in. My husband and I ride our bikes through the neighborhood. We walk through the neighborhood. We're in our 70s, and we love being here. We've been here, like I said, for 33 years. One home with a sidewalk would serve no purpose but to provide, as Eddie said, an eyesore, which they do not want, and neither does anyone else in the neighborhood. Note also that there have been several homes constructed in our neighborhood just in the past 5 to 8 years, and none have run into this obstacle. They all have secured their certificate of occupancy immediately upon completion of their homes. And the Eccles have not even been able to get a temporary certificate of occupancy. So this has been quite an inconvenience and costly on their part too. A number of our South Oak homeowners have submitted to the LUHO letters in favor of this variance. There are no homeowners that want this sidewalk, and as previously stated, neither does the family that we're moving into it. I have the list, and I don't think I have time or is necessary to read the list of the 25 people who did, their names and addresses, who did submit letters in support of this variance. So we're not asking to do anything that's not already been done since this ordinance was enacted. It was brought about, I think, in 1997. I'm not sure. I looked it up at one point in time, but I didn't write it down. So between that time and now, there have been a number of houses built. And again, within the last 5 to 8 years, there have been at least 2 houses that have been built. And no one has run into this before. I did contact Commissioner Stacy White's office. He is the commissioner for our area. And I finally received a letter this morning. I contacted him late. I received an email from his office this morning, and I'd like to read that. And this is from Megan Nixon. She is his legal assistant. Commissioner White does not support the interpretation of the LDC that requires sidewalks to be built in communities where there is no connecting or practicable future connection to a sidewalk network. And she contacted him, made sure she had his approval for me to read this, and I do have both of those emails if anyone needs them. But that's all I have to say. I just really hope, on behalf of my family and of our entire South Oak community, I respectfully request that this variance be approved. Thank you.
Thank you. And we also have Mr. Lewis.
Yes, ma'am. Thank you for letting me speak today. And as Pat so eloquently stated, my name is Chris Lewis, 4609 Clarksdale Lane. I'm the current president of the South Oak Community Homeowners Association. And I'm just here in support of the Eccles petition for variance to remove the requirement for a sidewalk there. The facts have been presented as eloquently by Mr. Bartlett, Dr. Eccles, and Pat Cook. Just wanted to echo that it's the 84 homes are in support of the Eccles petition, and no one has voiced an objection to it. And I'm just here to state that for the record. Thank you.
All right. Thank you for your testimony. Seeing no one else to testify in support, is there anyone that would like to speak in opposition? No one online, no one in the room. All right, Mr. Ratliff, we'll go back to county staff if you have any additional comments you'd like to make.
Nothing further.
All right, then, sir, you have the last word if you'd like it. Mr. Bartlett or sir? No? All right, then thank you for that. We'll close variance. Oh, did you want to speak? You're welcome to speak if you'd like. Yes, ma'am. Good afternoon.
Good afternoon. Just very quickly, I just wanted to say thank you, especially to our builder for taking his time today, for our friends and our neighbors. We're looking forward to be your physical neighbors really soon, and to thank you and the rest of the facilitators here for your time and consideration.
Thank you for that. I really appreciate it. All right, we'll close variance 2-1.
Ma'am?
Oh, you have to sign in. Yes.
Yeah. Oh, before you sign it, I need you to identify yourself and your address.
I apologize. My name is Michelle Eccles, and I'm at 10818 Barbados Isle Drive. Thank you.
Perfect. Thank you. All right, then we'll close variance 21-0688 and go to the next case.
Next case is item G6, variance application 21-0709. The applicant is David and Carmen Wilson. Request is a variance to lot development standards. Staff report was prepared by Colleen Marshall. However, I'll be making the presentation at today's hearing. The applicant is requesting a setback variance to accommodate a proposed home on property zoned RSC 6. In the RSC districts, a minimum front yard setback of 25 feet is required. Now, the land development code says that required yard orientations on flag lots and lots accessed by easements are oriented with respect to the roadway from which they are accessed, as if the lots abutted the roadway. In the subject case, the property is accessed from the east side via 13th Street Northwest. Therefore, the required front yard is located along the east lot line. The applicant requests a 15-foot reduction to the required front yard setback, but to allow a setback of 10 feet.
Thank you so much. Is the applicant here? Good afternoon. There you go.
Yes, my name is David Wilson. I'm at 202 13th Street Northwest in Ruskin. And we are asking for a 15-foot variance from the front east property line. The current structure built in the 50s is currently within that 25-foot setback on the east property line. Without the variance, we would be forced to build a house that is very narrow, because on the west side, we have a wetland area that we have to set back 30 feet. Or we would have to renovate the current structure, which was originally our plan was to renovate the current structure. But since it's in a floodplain, it's on the Ruskin Inlet. FEMA makes it very difficult to add any square footage to a house that's in the floodplain. In addition, the last hurricane season of 2020, which passed 60 miles off the coast of Tampa, sent water within a half an inch of coming into the current structure. So we were there that night when the water came up, and we were like, we really need to raise this thing up and do it right. So this project, number one, the benefits to this is it'll remove 2 septic tanks from the property, which would improve the water quality in the Ruskin Inlet. And number 2, it would remove a 2,000 square foot structure that's in the floodplain. And that's all I have.
All right. Thank you so much. If you could please sign in. Is there anyone here that would like to speak in favor? Seeing no one, anyone in opposition to this request? No one. County staff, anything else?
No, ma'am.
All right, then with that, we'll close variance 21-0709, and we'll go back to Ms. King for the sign case.
Right. This was item F1, variance application 21-0729, applicant Dr. Muhammad Halal, and Kim King will present staff finding.
Good afternoon. Kim King from Development Services. The applicant is requesting a variance for additional square footage on the west elevation of the building located at 3140 Falkenberg Road, Brandon Professional Plaza. Per section 70300A2 of the Land Development Code allows each premises, and in the case of multi-occupancy buildings, be permitted to have 1.25 square feet per each linear foot of building frontage facing a public street or parking lot, not to exceed a maximum of 200 square feet per building elevation. Just to give you a little background, is they were coming in to get permits for signs on the building, and it came to light that they had not all their tenants faced Falkenberg Road. Some of their tenants were in the back of the building, but they want to be able to put all the tenant names on the front of the building. So we're looking at this as a unified development. And so today they're requesting to have 150 square foot of additional sign area for multiple building signs to allow a total of 350 square feet on the west elevation of the building. That concludes my report.
All right, thank you so much. Is the applicant here? Good afternoon.
My name is Jason Chokal. My name is Jason Chokal. I'm here representing Dr. Muhammad Allow, address 3140 South Falkenberg Road, Riverview. Thank you, Kim, for that report. What I'd like to do is just kind of give you guys a little bit of a background to kind of let you know how we got to this point and what would really help us out with the building. I've put a little picture there for you to see, and I'll put some other ones up so everyone else can see what the building looks like.
Excuse me, sir. Would you please pull your mask up? Thank you.
It's a unique building. We built it in 2015, and it was designed with the purpose of having several medical offices. And what happened over the years is that as the different suites were sold, we didn't sell the larger pieces like we thought we would. So we ended up having many more smaller offices than were intended. So a couple of the things I wanted to show you. This is the original plan of the building. So there's a north tower and a south tower. The north tower has 3 floors and the south tower has 2. The original designation would have been 1 suite on each floor. So if we had 101.
Sir, you need to be at the microphone.
101 and 102 would have been the first floor. 201 and 202 for the second floor. And then 301 for the third floor. The other side, that's the rooftop access. But as I mentioned, we actually sold them off in smaller chunks. So, and these can be entered in the record. These are site plans and site surveys. What you're looking at there is the first floor. It got split in half. So there's now 102 and 104, making an extra suite. Initially on the south tower, the suite that was only supposed to be, one large one got cut into 3, 202, 204, 206. Similarly, on the north side of the second floor, there were 3 offices that were built. There's 203 and then also 201 and 205. So I just wanted you to see that to get a better understanding of kind of how it came to be. Some of the numbers, as Kim had mentioned, the code, the ordinance states 200 is the allotted size. Right now we're at 201 with the 6 signs that exist currently on the building. There are 2 suites left that are in the permitting stage to add their signs to the front of the building. One of them has been there since last summer. They got their certificate of occupancy in May, and this whole conversation began last summer. to add their sign onto the front of the building. And the second one just ended a couple weeks ago. And so they both currently have temporary banners hanging on the front of the building. The next one up is TGH Cancer Institute. That is just a simple schematic to kind of see what that one's going to look like. And the other office is called Sanitas Medical Center. And I wanted you to see theirs. Okay. And then finally, I guess I'd like to show you just the current picture of kind of what it looks like right now and then what we would like it to look like is kind of. You see that?
Yes.
So as you can see, there are 6 real signs, and then the 2 that are the banners. The Cancer Institute is in the center, and then the one that's down there at the bottom right, the big white one, it's kind of blurry. That's the Sanitas sign, and that's they're hanging right there. Like I said, temporarily, but they would ultimately like to be placed up top, as you can see in this little area in the center there. What makes this building unique? And it's, first of all, we had no idea this was going to happen. You know, again, the original intent was to sell off 5 or 6 large spaces, and then we would have had enough room for the signs, but we ended up selling, there's currently 10 suites instead of 6. It's a medical office building, so we're not doing this for any sort of personal gain. It's just really to help our clients, and our population is mostly an older population, and so they're very much in need of assistance with the signage. And the trees on the front of the building along Falkenberg Road, they presently make it sort of difficult to see. So having the signs up high on the building like we would like to do is beneficial to people driving by to avoid accidents or problems or situations that may occur. So we just request the variance to increase it to 350 so we can take those 2 temporary signs, make them permanent signs, and everybody will be happy. That should be all.
All right. Thank you so much. If you could please sign in, and you're welcome to submit whatever you'd like into the record.
Okay, thank you.
Is there anyone here that would like to speak in support? Seeing no one, anyone in opposition to this request? All right. Ms. King, anything further before we close?
No, nothing further.
All right. Thank you. Then with that, we'll close variance 21-0729, and we'll go to the special uses.
Okay, yes, that concludes our variances. So we now move to section H, special uses. First case is item H1. Special use 21-0306. The applicant is Costanera Peruvian Cuisine Restaurant. The request is for a 4 COPX alcoholic beverage permit, which requires a separation waiver. Staff report and recommendation will be presented by Tanya Chapella following the applicant's presentation.
All right. Is the applicant here? Oh, sir, if you could take your graphic down. Thank you. Good afternoon. How are you?
Good afternoon. My name is Rodolfo Schaefer, 3316 West Catalina Street, Tampa, Florida, 33607. I'm here to request a waiver for 4 COP, beer and wine and liquor consumed on premises only for Peruvian, Costanera Peruvian cuisine.
All right. It looks like from the staff report, the waiver is because of a child care center.
Yeah.
Did you talk to them about your request?
Yes. Yeah. They don't have any objection. Also, the daycare is way behind us, is in the limits, but it's way behind us, separate with the wall, behind the building.
All right. Well, that was my only question. Thank you, sir. If you could please sign in with the clerk's office. All right. Development services.
Good afternoon. Tanya Chapella, Development Services. The applicant is requesting a distance separation waiver for a proposed 4 COPX alcoholic beverage permit at an existing restaurant, Costanera Peruvian Cuisine, at 3869 Nordell Boulevard. The wet zoning does not comply with the separation requirement from certain community uses, and there are more than 3 existing wet zonings of the specified types within 1,000 feet. A childcare center, Nordale Kindercare, is located 78 feet to the north of the proposed wet zoning, and there are 9 existing wet zonings of the specified types within 1,000 feet, 3 of which are located in the same commercial building as the proposed wet zonings. The proposed wet zoning is located in an established commercial area, which includes numerous businesses that sell alcoholic beverage. The proposed wet zoning will increase the number of specified wet zonings within that radius, but will replace a wet zoning that permits on premises consumption, of beer and wine in connection with a restaurant, and therefore represents an incremental change in the established alcohol use. Additionally, several of the other specified wet zonings are located in the other shopping centers with no functional relationship to the center in which the proposed wet zoning is located. Therefore, staff finds the proposed wet zoning does not pose a significant impact on surrounding uses. Staff has received no objection from the operator of the childcare facility or property owner. Staff finds the proposed 4 COPX wet zoning approvable subject to the following condition. Upon approval of alcoholic beverage permit US AB 210306, the existing 2 COPRX alcoholic beverage permit on the premises AB 940073 shall be rescinded. This concludes my presentation. I'm available for any questions.
No questions at this time, but thank you. Is there anyone that would like to speak either in favor or against this application? Seeing no one in the room, no one online. All right, county staff, anything else before we close?
No, ma'am.
All right, I see the applicant has left, so I guess that means he's done. Then we'll close special use AB 21-0306 and go to the next case.
Our next case is item H2, special use 21-0331. The applicant is Fins AB LLC. The request is for a 4 COP RX alcoholic beverage permit, which requires a separation waiver. Staff report and recommendation will be presented by Kevin DeFrank following the applicant.
All right, is the applicant here? I have one person online. Are you Mr. Disser?
Yes, I am.
Good morning. My name is Colin Rice, attorney on behalf of Mr. Disser, who is present virtually this morning. 101 East Kennedy Boulevard, Suite 2800, Tampa, Florida 33609.
Thank you.
Okay. Got a couple visuals here for you. Okay, so we're here this morning on a special use application for a 4 COP RX alcohol permit. The site is 1112 Apollo Beach Boulevard, and I'm showing you here an aerial of the site, which is currently vacant. And here we have a general location map, give you a better sense of where it is in Hillsborough County. The map to the top right is the future land use. All of the yellow area is R6. Our site is shaded in pink. And this is part of a planned development site plan from the 1970s. The restaurant and bar use that we're seeking is supported by both the future land use and the zoning. And this site actually has a previous similar type of approval for COP RX from 1996 that is still active, but was not constructed. To give you some of the details on what is already approved out here, right around 8,000 square foot restaurant, about a 2,800 square foot deck. And there were some conditions in place, no outdoor loudspeakers, outdoor unamplified entertainment permitted till 10 p.m. And again, this is about a 25-year-old approval to give you some context of what's allowed out here. And as we emerge from a post-COVID-19 world, it's become increasingly popular to make better use of outdoor spaces. And it seems nationwide that this is a trend that is going to stay and survive post-COVID. And that's precisely one of the parameters that we're looking to change here, is make use of this beautiful waterfront property and have increased outdoor flexibility and options for patrons. And for our proposal today, we want to thank staff as well for their hard work in this. This had been continued previously, so we could sit down and really think about how to present this, what conditions would make the most sense, and how to orient the structure in a way that works for everybody, and to bring it up to current standards and the current needs of the market and the community. Again, for COPRX, we'll have a slightly smaller interior structure, about 5,000 square feet, with a 3,000 square foot covered outdoor deck, and then 10,000 square feet of uncovered outdoor area. In addition, we've done three things. We've agreed to condition language that there'll be no amplified music after 11 p.m. and operations will cease at 1 a.m. The third thing, not a condition, but in partnership with the residential community to the south, Bella Soul Condominiums, the structure will be oriented closest to their property line. So the majority of patronage will happen either buffered by the structure or to the north of the structure. So it's got a little more robust distance separation. And this letter was submitted onto optics as well, so it's part of the record. We're proud to have earned the support from the Bella Soul Board of Directors. They want to see this project happen. Mr. Disser went to great lengths, had numerous meetings with them, say, hey, here's what we're proposing, here's what's allowed. How can we work together on this? And we were able to craft conditions and an orientation for the site that made them comfortable. So we're, again, proud to have received their support. To give you a little better idea of the surrounding area, this is Circle's Restaurant to the north, just over 300 feet to the north, separated by a parking lot. Just again, another aerial for your context. And again, you know, we're proud to have earned staff support. They found that this is not a dramatic departure, no introduced, no additional impacts to the community from what had previously been approved. Again, myself and Mr. Disser are available for any questions. We respectfully ask for your approval today. Thank you.
My only question was about your interaction with the neighbors, but you described that, so thank you.
Great, thank you.
Appreciate it. All right, development services. Oh, did Mr. Disser want to add anything before we move on?
No, thank you.
Okay, thank you so much. Development services, please.
Could I actually have him identify himself and give his record?
Yeah, Michael Disser, 2804 West Parkland Boulevard, Tampa, Florida.
Thank you.
Good afternoon, Kevin DeFrank with Development Services. Now for this case, as the applicant or Mr. Colin Rice explained, the request is for a distance separation waiver for a 4COPRX AB permit for a proposed restaurant to be developed on a vacant parcel at 1112 Apollo Beach Boulevard. And the subject property is zone PD 77-0123 as most recently modified by PRS 20-0384, which permits the proposed use and consideration of the requested AB permit. Specifically, the applicant requests a 129-foot reduction to the required separation distance from a residentially zoned property to the southwest to allow separation of 21 feet. And staff findings includes the following: that the proposed restaurant will be located on a vacant property that has been wet zone for 4COPRX use since 1996. And the existing wet zoning comprises of 7,956 square feet of area and is subject to the following conditions, where there shall be no outdoor loudspeakers. Non-amplified entertainment outdoors shall be limited to performance standards of section 2.6.4.69.2 of the Land Development Code. Non-amplified entertainment activities may occur outdoors when the restaurant is open until 10 p.m. daily. Additionally, the proposed wet zoning is the same category as the existing wet zoning, and the proposed conditions to end alcohol sales at 1 a.m. each day, whereas the Land Development Code allows alcohol sales and services until 3 a.m. daily. Additionally, the applicant has proposed to prohibit outdoor amplified music at 11 o'clock p.m. daily. And the normal route of travel from the proposed wet zone footprint to the driveway entrance to the adjacent multifamily residential development is approximately 340 feet, which exceeds the required separation distance from the residentially zoned property. And as the applicant provided, there's a letter from the Bellisville Homeowners Association Board of Directors in support of the proposed wet zoning. And the proposed wet zoning is within the vicinity that includes a number of restaurants that are wet zoned and are other non-residential waterfront uses, such as marinas. Furthermore, staff finds the proposed wet zoning consistent with the mixed-use character of the area, with residential uses in proximity to commercial uses. And staff further finds the proposed wet zoning comparable to the existing wet zoning on the property that has been in place since 1996. And for those reasons, staff finds the proposed wet zoning does not pose significant new impacts on surrounding land uses. And staff finds the request approvable subject to the following conditions, which include the sale and or consumption of alcoholic beverages shall be limited to the following hours: Monday through Saturday, 7 o'clock a.m. to 1 o'clock a.m. the following day, and Sunday, 11 o'clock a.m. to 1 o'clock a.m. the following day. And outdoor amplified music shall be prohibited after 11 o'clock p.m. daily. And upon approval of alcoholic beverage permit SU-AB 21-0331, the existing 4COP-RX AB permit on the property AB 96-0344 shall be rescinded. And that concludes the report, and I'm available for questions.
No, you covered everything. Thank you so much. Is there anyone in the room or online that would like to speak in support? Seeing no one. Anyone in opposition? No one. County staff, anything else?
No, ma'am.
All right. And sir, if we're going to close, unless you would like to add something else before we close. All right. Thank you. Then with that, we'll close special use AB 21-0331. Go to the next case.
All right, next case is item H3, special use 21-0595. The applicant is Triple Taurus LLC. The request is for a 4COP-RX alcoholic beverage permit, which requires separation waivers. A staff report and recommendation will be presented by myself following the applicant's presentation.
Good afternoon. If you could turn the microphone on. There you go.
Okay, well, good afternoon. My name is Terry Haley, 108 Clock Tower Drive, number 157, Brandon, Florida. I am representing the Triple Taurus LLC, doing business as Three Bowls Tavern and Brewery. They're located on the southeast corner of Belshode Roads and Glen Haven in Valrico. Their request is to upgrade to a 4 COP-RX license, having the restaurant requirement attached to it. Little history of the business is It was the third location some 30 years ago of the Beef O'Brady's chain. It has been there ever since. And at the same time of opening there, the kinder care, which is our requirement for a variance today, came about. We can't remember who was the chicken, who was the egg, or which came first, but it was right at the same time. Well, for almost 30 years, it operated as Beef O'Brady's against the kinder care. And then in spring of 2019, the same family, second generation of the Melodies, their dad was the founder and organizer of Beef O'Brady's. The children took over and they wanted to try a new concept here. It's been well received, but of course, with the virus coming in, they've hit as a new business some speed bumps and stuff. So to create another avenue for a revenue, they wish to obtain liquor to it. Basically, the three types of hurdles that we must clear in order to get this were residential properties. We met that requirement, distance requirement. Also, of other alcoholic beverage licenses, there's only 3 allowed. We met that requirement. Our third and final was the requirement of community service. That's where we hit our small roadblock. And what that is property overlapping. They do like a community use there and have since day one of the parking area. The property of a kinder care daycare learning center falls 65 feet from the rear of my client's establishment. If you do move over to the building, it's another 65 feet, but the requirement is 500 feet. So we're asking for a 435-foot variance. In our packet, we do have a letter of support from Kinder Care. Again, we've been neighbors, and I actually think some of their former students are probably some of our customers now as the years have gone on. But we did get one known support from the community. These guys have a great track record. They just want to go with this second concept, maybe grow it with more, but at least this one have another avenue of income.
And no opposition from the kinder care.
No, but like I say, we have end of file letter of support from them saying that they've never had an issue. I know of one that I turned in was a gentleman sent it to me, just a citizen around. And again, if you looked at the 30-year track record, I mean, there's the only law enforcement you would see there would be as a patron. In fact, there used to be a substation of the sheriff's office within the center. And if you look on my little diagram here, the red is property owned by the center itself. And just on the, this is north, down here pointing down, just on the corner back is where you'll see the building of the kinder care. Like I say, plus another important thing is most of our customers at Three Bulls enter from Bell Shoals, while the patrons and customers of the kinder care enter more so on the north side at Glen Haven.
Okay.
So again, that's all we're asking for that request. We do have support of the community.
Perfect. Thank you so much for your testimony. If you could please sign in. Development Services, please.
Tom Hisney, Development Services. The applicant has summarized the request quite well, so I'm going to focus on staff findings. However, I would like to point out that the 4COP-RX license category is subject to only 2 separation criteria. That is 500 feet from community uses and 150 feet from residentially zoned property. The third criteria that the applicant pointed out, the number of other wet zonings within 1,000 feet, does not apply to this case, which is why it's not addressed in the staff report. The existing 2 COP-RX wet zoning premises allows the sale and consumption of beer and wine in connection with a restaurant, and it has been in place for approximately 28 years. Therefore, the proposed addition of liquor sales and consumption by a restaurant represents an incremental change to the established use. Additionally, the separate requirements that were in place for the 2 COP RX wet zoning are identical to the separation requirements that are in place for the wet zoning proposed today. The restaurant faces west away from the child care center, which is to the northeast, and the walking distance between the front entrances of the proposed wet zone premises and the child care center is approximately 400 feet. Finally, the applicant has submitted a letter from the child care center stating they are in support of the application. Therefore, staff finds the proposed wet zoning approvable, subject to condition that upon approval of the subject wet zoning will rescind the existing wet zoning on the property.
All right, thank you so much. Well, at this time, we'll call for anyone that would like to speak in support.
We do have one of the owners here.
Sure. Good afternoon. Good. You give us your name and address, please.
Does this mean it's on? Okay, it's on. My name's Tracy Melody. I live at 5205 Culasaja Circle in Valrico, Florida. And I just basically wanted to come up here and just reiterate, in a post-COVID world, everybody knows what COVID did to the hospitality industry. And trying to get liquor is just going to help us be able to survive, quite honestly. It's just a situation where the new normal has just shifted everything. So our profitability is just not as great as it used to be. And when we came up with our business plan in 2018, like everybody else in the world, no one thought a pandemic was going to ever happen. So we are, we own the shopping center there. We live in the same community where our shopping center is. We've also lived in Brandon for 35 years or more. Beef O'Brady's, our family started Beef O'Brady's. We are very committed to this community, and we are just basically trying to have a family-owned business in this community and service the community as best we can. A lot of people don't want to drink beer and wine. They want to drink spirits. So anyway, that's all I got. I just wanted to come up and say hi. And thank you
very
so much for your time.
Thank you. If you could please sign in with the clerk. All right, anyone else that would like to speak in support? Seeing no one, anyone in opposition to this request? No one. County staff, anything else?
No, ma'am.
Sir, anything else? All right, then with that, we'll close SUAB 21-0595 and go to the last case.
Okay, the last case today is item H4, special use 21-0730. The applicant is Baru FL LLC, requesting a 2 COP beer and wine. 2 COP alcoholic beverage permit, which requires a separation waiver. Staff report and recommendation will be presented by Isis Brown following applicant's presentation.
All right, is the applicant here?
Yes, ma'am, I'm online.
Oh, good afternoon. Please give us your name and address.
My name is Christian Brugal. I'm the owner of Brew Florida Growler Bar, located at 8729 Gun Highway in Odessa, Florida. And I'm here today. We are seeking a special use distance waiver request related to homes that are 250 feet, within 250 feet across the street, and a daycare center that's within 500 feet down the road. To give you a little bit of backstory, we've been open for about 3.5 years, much like Three Bulls Tavern. The pandemic hit us quite a bit. And we are essentially just looking to expand our existing space. The unit or property next to us became available a few months ago, and as a way to have a little bit more space and provide a little bit more more of a level of comfort for some of our guests, as our existing space is just about 1,000 square feet, and it's quite tight there. We wanted to see if we can go ahead and expand. So just looking to take over the unit next door and basically continue operating in the same capacity that we've been operating for the last 3.5 years.
All right, does that conclude your presentation?
Yes, ma'am.
Thank you so much for that. I appreciate it. Development services, please.
Good afternoon, Isis Brown, Development Services. Special use 21-073, pursuant to Land Development Code Section 61111. The request is for a distance separation for a 2 COP alcoholic beverage permit for the sale and consumption of beer and wine on and off the permitted premises package sales. The proposed wet zoning is sought by an existing tavern, Crew Craft Beer, Brewers, located at 8729 Gun Highway in Odessa in a commercial center. The property is zoned CG, which allows a consideration of the proposed wet zoning. Per the survey received April 27, 2021, the proposed wet zone area will comprise of 2,241 square feet of indoor area and 857 square feet of outdoor area for a total of 3,278 square feet of total area. The subject tavern currently has a 2 COP wet zoning pursuant to special use 17-0074 that was approved in 2017 for 1,342 square feet, comprising of 979 square feet in indoor area and 363 square feet of outdoor area. As the applicant stated, he wishes to expand the footprint, and he's going to be the proposed expansion is into 8727 Gun Highway. So the two waivers he's applying for is for the community uses, which is the Keystone Child Academy, which is located approximately 364 feet, which is within that 500-foot buffer. And then also a residential zoned property, PD 840098, which is approximately 175 feet west of Gun Highway. Staff findings. For the approval of separation waivers, the proposed wet zone is separated from the residential property to the west, which has a right-of-way of approximately 125 feet at this location, and single-family homes are buffered by a masonry wall and a row of mature oak trees. The proposed wet zone is currently located in the center of the shopping center, and therefore will be screened from the child care center to the south. Staff has no objection. We received no objections from the child care center facility or the owner, and no other businesses in that area objected to the request. Due to the circumstances proposed by, due to the findings, staff's findings, staff finds that upon approval of the 2 COP alcoholic beverage permit, special use 21-03, the existing 2 COP alcoholic beverage on the premises will be rescinded. I'm available for any questions.
No questions at this time. Thank you. Is there anyone that would like to speak either in favor or in opposition to this request? Seeing no one in the room, no one online. County staff, anything else before we proceed?
No, ma'am.
All right, then with that, we'll close special use 21-0730 and adjourn the hearing. Thank you all for your time and testimony.
Thank you.